Yes, call the list. Take the memo.
My lord, there is one typographical error in judgment.
It will come. Please give it to the court officer. I'll give a date. It will come on Monday.
Wait.
Please with a small list. Call.
Yes, sir. The list number 1, parted matter, serial number 1, Muhammad Tahir.
Where is he?
Respondent 2 and 3 euro. Respondent number 2 and 3 euro.
My lords, this is the matter yesterday.
I remember.
Give the file, no?
Just call it after
Yes, sir.
end of the list.
Yes. For orders matter, serial number 2, V. Mohan.
You have instructions? You have instructions?
Yes. Increment has not been complete, my lord.
No, it is
As
complete,
on
my
date,
lord.
4 crore 20 lakhs is there, my lord. On 15
No,
Jan-
one minute. Let me look at the interim order. When was it passed? Issue emergent notice to the respondent. Interim order as prayed for is granted, subject to depositing of 20% of the outstanding amount. What is the outstanding amount?
4 crore 20 lakhs.
No, not that.
4 crore 20 lakhs. Then what is 20% of it?
It comes to 58 lakhs, my lord.
8 lakhs.
58 lakhs I paid, my lord. I'm producing the proof of, I'm filing a memo, proof of payment, my lord.
It was directed to be paid when?
Yeah, bank directly to them.
Within 4 weeks from today.
But there was a delay, my lord. There was a delay.
No, let's please argue on the merits of it.
In the meanwhile, my lord, on 15/10, they have trespassed the property, my lord. We have registered a complaint also to SP. I produced that copy.
We'll hear the matter.
Yes.
Please argue.
Next week, my lord, not right. Can we have it on next week?
My lord, sir.
We'll give a date and I'll close it on the day.
Yes, ma'am.
Lissus matter.
In the meanwhile, direct them to return the position, my lord.
How can you take position?
Already I paid the amount, my lord.
So
I paid
for
the.
4 crores, if you pay 8 lakhs, that
No, no,
means that.
58 lakhs,
No,
madam.
no, 58 lakhs. What is the order of the court? Did the court ask you to, take
20%
possession of the property? Let's see, what is the order?
No, ma'am.
What did the court say? Interim order, what is the interim order that you sought
Section
for?
14 was stayed, my lord.
Then in that case,
I paid the 58 lakhs of 20% of the loan outstanding. I'll demonstrate the next day.
no, it is not that. How can you take the possession of the property?
I have no instruction. There.
Sale
That
notice has
portion-
been issued on 18/9/2025.
18? The learned counsel appearing for the respondent submits that the petitioner has forcibly entered into the property. The interim order that is passed by this court is to pay an amount of rupees
58 lakhs.
20% of the outstanding amount within 1 month from today, that is 19/11/2024. This order ought to have been complied by 19/12/2024. According to the petitioner, he has paid 58 lakhs and according to the respondent, as per the order passed by the court, the order was not complied with, and in fact, after the order is passed, they have forcibly entered into possession of the property. The interim order that is sought is
In 14 order.
1 minute. They sought ex parte ad interim stay of the order dated 11/11/2024. Possession was taken,
Not, a position was taken, my lord.
date
On 26/5, my lord.
on 26/5/2024.
25.
The possession was taken on 26/5/2024.
25.
25.
Position was taken on 26/5/24.
How can you take possession on 26/5/25 when the stay is granted on 19/11? I think something wrong with the dates.
Dates are there.
If you must have taken possession before this order.
Yes, my lord.
It is submitted that they've taken possession. And now, after the interim order is passed by this court, the respondents are the petitioner has forcibly entered into the property. Then counsel of the petitioner submits that he'll get instructions in this regard. This is matter on
11th November 2024.
11th.
On 11th November 2024.
Then that is 11th wrong. The position was taken on 11th November 2024. When by the time the impugned order is passed, when the bank has taken the possession, the petitioner cannot forcibly enter into the possession of the property. There is no order directing the respondents to redeliver the possession. There is this matter on 17th of November. By the time the petitioner shall get specific instructions, or even otherwise, the matter will be disposed of. No further time will be granted.
Cell number 3.
Position and
Huh? Why will we do it now? Yes.
Cell number 3, Siddharth Suman, for petitioner DS Jeevan Kumar.
For the petitioner.
Yes.
Kindly see the orders. Last occasion, my lords,
Yes.
on 16/10.
1 minute.
There's
The
a deed-
respondents are at liberty to go ahead with the sale as per the notice dated 11/9/2025. However, they shall not confirm the sale till 3/11/2025. The petitioner shall pay the amount of rupees 2 crores by 30/10/2025. This is matter on 31/10.
Unless we have not paid that amount, we are seeking for some more time to pay that amount.
These are not the cases where there has to be any indulgence from the court.
So I oblige.
But still, the court considering the facts and giving an opportunity and at your submission that you will pay it, granted an interim order. Once an interim order is granted and not complied with, question of extending it will not arise. That's what is before this. court.
Further, my lords, the property has already been sold in the auction. We will have to confirm, my lords, because we have received.
Yes, please come.
Unless at least if the order is also vacated, let this petition be pending, my lords, we'll argue on the merits. So,
Uh-huh.
unless there is a petition be pending, my lords.
They will have to go under section 30, my lords.
No. How can, what is the purpose of keeping this petition pending? When once the interim order is not there, no, they will issue the sale notice. I mean, they will
certificate.
confirm
Our
the.
instructions were auction didn't take place on that date, my lords.
My lords, as of from the bank, I'm telling auction took place. my lords.
My lords, okay, sale
So
certificate.
please understand, once the auction takes place, once they issue the confirmation, this becomes infractious.
My lords, it won't become infractious until sales certificate is granted, my lords. They have 1 month to pay that amount, my lords.
So what
Till
will you
then-
do in 1 month?
My lords, till then we'll try to convince my lordship on the merits of the case, my lords. It may
What
be-
is the
my
matter?
My lords, if they want to argue, let them argue, my lords. This is
Yes,
only a time.
Yes.
My lords,
from
weeks time may be
2000
given, my lords. Interim order may not be extended, my lords. but,
2015,
it may be
my lords.
pending, my lords.
2015
Warrant
is
of
the last.
attachment passed by the recovery officer, debt recovery tribunal. Is
Section
bad.
30, there is an appeal provided.
Sale dated issued by the recovery officer, debt recovery tribunal is bad. There should be some legal ground. One legal ground you tell the court.
My lords, our contention, my lords, agricultural land, my lords.
Huh?
It's been exempted, my lords, from attachment to that legal ground.
That is argued at length on that day.
My lords, we'll
Only
try to-
because there are no legal grounds, but on the ground that you're ready to pay the amount, I have granted this. List this matter on
Plus
on 11th of November.
We may
Oh,
proceed in
one
confirmation.
minute. 11th of November. Before that, this court on 16/10/2025 had directed the respondent to go ahead with the sale, but not to confirm the sale till 3/11/2025. As the learned counsel for the petitioner has submitted that they are ready to pay an amount of rupees 2 crores by 30/10/2025. And directed the matter to list this matter on 31/10/2025. By the time if the amount of rupees 2 crores is not paid, the stay granted by this court stands vacated. It is submitted with the land counsel to the respondent that the amount of 2 crores as per the order dated 16/10/2025 is not paid.
And
Hence-
from amount from 2015, they have not even paid one single rupee.
Right from 2015, no amount is paid. In that view of the matter, the respondents are at liberty to confirm the sale. The land counsel of the petitioners submits that they want to argue on the merits of the matter. In fact, the court heard the matter on the merits of it. And as the court felt that there are no merits in the matter, however, considering the fact that he is ready to pay the amount, this interim order is passed. However, as a last opportunity to the petitioner, list this matter on 10th of November. No further time will be granted. In all these matters, wherever I said no further time, you should reflect in the cause list. Yes.
Serial number 3, 4. Hearing on interlocutory application, serial number 4.
Paper the
Sat Kumar
petitioner.
Shetty, Narayan
Kindly
Swamy.
maybe list on Monday, Your Lordship. There's a medical inconvenience in here.
My lord, the copy of IA has not been served on us.
I'll furnish it.
It is submitted at some difficulty to the petitioner, counsel. List this matter on 11th of November.
Till then, you know, the extension. Interim order is granted.
Interim order earlier granted is extended. Serve a copy on her. If
I'll
you don't
serve it.
serve on that day, I'll
I'll
discuss.
serve Your
with you.
Lordship. I'll serve.
Counsel shall serve the copy of the writ petition and the counsel appearing for the
Respond number 2, my lord.
respondent number 2 bank.
Yes.
Yes.
Obliged.
Interim order earlier granted is extended till then. Next.
Serial number 5, R. Shashidhara.
Respondent bank.
Any interim order in this?
Interim order is there, my lord. What had happened, there was no specific date fixed.
Let
in
me
the-
see. Interim order as prayed for. We'll
Totally
have it this also on 10th.
10th month.
10th. This is matter on 10th. Learn counsel for the respondent submit, sir. The interim order is not complied with.
Yes, complied.
It's
That
complied,
is
yeah.
Actually, what had happened, my lords, there was no specific date fixed, my lord. After that.
The
they
learned
applied.
counsel, at the request of learned counsel for the petitioner, list this matter on 10th of November. No further adjournment.
Serial number 6. Preliminary hearing 6.
Yesterday's matter will be listed today. Today's afternoon sale is at around 11 o'clock. So for that, now, I make only 2 or 3 submissions. See, the same
Why
property.
the clients are in the court? Why the clients are in the court?
Party has come.
Not necessary.
So, I personally, this notice is issued, not being delivered to me.
Huh? Please use the mic.
Not issued or delivered to me directly or post, but this notice has been received through one of the petitioner's WhatsApp mobile number. So on the basis of that, we went to the administration office of this respondent bank in Tumkur. There only authority. We went and met
This is the last payment made by him.
at 8/9/10/2025.
By virtue of this court's order.
That's what. One minute.
Let me complete, sir, please.
That's what I
Asking some
said.
question. You'll not let the lawyer to speak.
I wanted to
You'll
come.
not let
I
the judge
wanted
to
to come
speak.
for that.
You've only
I
gone
want-
talking.
I
Every
wanted,
time, my lords.
1 minute.
And even from the bank also, I do not expect these kind of aggressive
Ah.
statements.
Right, because we are aggrieved.
They want, please wait. They have their own problem. They want, whatever is the problem of the client, they want to place before the court. Court will hear you also. What I expect from both the advocates is have some.
Obliged, I'm sorry.
Please wait, and I'll hear him and also will hear you.
That's it, before that.
Yes, no, not before that. I'll hear him then and ask you.
By virtue of this court's order, my lords, 25 lakhs what,
What was the order of the court?
this court's order is there in page number 80 of the petition. Page number 80 of,
Separate petition.
that was separate petition.
On the same impugned order, same notice.
It was in page 80, my lords,
Page?
80.
Uh,
Before that, my lords, a brief history.
It was on 9th October 19.
9th October, what had happened in earlier sale, in the previous,
This is question.
I'm coming to that. In earlier sale, he filed appeal before DRT. DRT imposed him condition of 60 lakhs. He could not pay 60 lakhs. He filed this writ petition on the fact
What is that order? DRT order?
DRT
number?
told you pay 60 lakhs.
The number, SA number,
SA number is not
SM 334 of.
334 of 2025,
dated 22/9.
dated 29/9/2025.
Hmm.
He did not pay that money, and the fact, when the date was expiring for the last day for the payment,
Directed to pay 60 lakhs.
60 lakhs. From the date,
Outstanding?
outstanding is more than 4.25 crores.
Sorry to say
On the
that.
fag end.
Not
last-
60 lakhs.
Sir,
Not 60 lakhs.
Mr. Counsel.
Okay.
For every sentence you want to respond, how is it possible for the court to hear?
On the last day of the fag end day, maybe he come before this court. This court told you pay 25 lakhs. You pay 25 lakhs to save your property and file a IA for modification before DRT. This is by virtue of this order, he has deposited 25 lakhs.
Oh, this essay order is questioned in this writ petition.
Yes, yes, no,
Let's
this,
see-
the-
let's
the-
see the-
no, my lords, this essay order was questioned in this writ petition, but subsequently sale did not take place. So that essay also became infructuous. On this writ petition, as per the order of this court, after lapse of 10 years, he paid me 25 lakhs. 2015 was the last payment. In 2025, virtue of this order, he paid me 25 lakhs. Now I issued a fresh sale notice. This fresh sale notice in earlier sale notice, he approaches DRT, which he is very well knowledge that under section 17 appeal has to be filed. Now he has chosen this forum by telling there is no effective and efficacious and alternative remedy. That's the reason he has approached this honorable court.
No, this ground of 13(2) not being served.
Yes, I'm coming to that.
One minute.
Everything is there, my lords.
What is that I'm going to ask you? Tell me.
Absolutely, everything is there.
No, what is that I'm going to ask?
Everything is there.
No, no, what is that I'm going to
Yes,
ask? I said this 13(2), 13(4), did he raise these issues in the earlier writ petition?
Absolutely no.
That's what.
Absolutely no.
Yes.
And kindly, my lords, this is a
Exactly.
witch and all the petitioners who are coming before this court are making these common allegations. Bank has not issued me, are not issued. In this case, my lords, personally, it was issued by 3 people. Personally. Kindly come to page 4, my lords, in the list of page 4. Demand notice was issued in 10/8/2019. 3 people, including the petitioners, all have signed personally. And now they come and say, I did not receive demand notice, I did not receive position notice. Kindly come to position notice, my lords. Kindly come to page 9. The position notice will start. The sent postal RPADs, all returned acknowledgements, paper publication. And so I'll pause here and I'll just take one case law of Honorable Supreme Court, my lords, where Supreme Court has clearly dealt with exactly the same matter. Where similar such case, on a DRAT DRAT's dismissal of case, the borrower had approached High Court. High Court, in fact, had decided everything, whether 13(2) is issued or not, all these things, where Supreme Court told.
Let's read.
Kindly come to.
Paragraph.
Notes, this is yes, sir, polymers versus Alpine Pharmaceuticals. Yes, sir, polymers. Second case law. First one is with respect of alternative remedy. The second case law is Lordship got it. Yes, sir, polymers versus Alpine Pharmaceuticals. Lordship may kindly come to para 13.
Yes.
It starts from para 12. I'll read from para 12 for more elaboration and more.
Yes.
On the second question, reference was made to section 17(1) of the SURFACE Act, which deals with the right of appeal filed by a party aggrieved by the measures referred into subsection 4 to section 13, relying on the decision of this court in Indian Overseas Bank and Ashok Sawmill. It was held that the series of steps from the date of auction by the secured creditor under section 13(2) of the SURFACE Act up to the date of auction and sale confirmation can be challenged by a borrower when it challenges the measures referred to in subsection 4 to section 13 under section 17 of the SURFACE Act. In this view of the matter, the High Court, with respect to the second issue, held that though OA was filed in 1/10/2018, the borrower can challenge the position notice issued on 3/3/2017, taking symbolic position, taking physical position in May 2017. The sale notice issued on 2/7/2018 and the sale certificate dated 27/9/2018, as they all form part of the same cause of action. Consequently, it was observed that the challenge to the auction measures prior to 2/7/2018 would not be barred by limitation. Now the conclusive part, my lords. In the view of the factual matrix of the present case, which has been set out in detail and the aspect of waiver and estoppel discussed subsequently, it is not necessary for us to examine the question of violation of section 13(3)(a) of the SURFACE Act and also whether the cause of action from the date of issue of notice under section 13(2) of the SURFACE Act till the issuance of sale certificate is a continuing cause of action. Suffice it would be to observe that in ITC Limited, this court, in spite of holding that there was a violation of 13(3)(a) of the SURFACE Act and consequently the notice of position under section 13(4) was vitiated, had allowed the appeal in view of the attendant circumstances set out in the subparagraph of para 30 on the ground that the debtor post the notice under section 13(4) of the SURFACE Act had given proposals with assurance letter of undertaking for repayment of the mortgage debt pursuant to which the time was granted, and consequently the sale notice was deferred. Only when payments were not made as promised, the creditor has proceeded to recover the loan dues. But now I'll directly go to para 15. We would like to elaborate on the aforesaid principle as a dictum as declared in ITC Limited will equally apply to the proceedings before DRT, debt recovery tribunal and appellate tribunal under the SURFACE Act. The principle applied is that of waiver and estoppel. This is very important, my lords. Waiver is an intentional relinquishment of a known right. Waiver applies when a party knows the material facts and is cognizant of the legal rights in that matter, and it, for some consideration, consequently abandons the existing legal right, advantage,
Consciously.
benefit, claim, or privilege. Waiver can be contractual or be express conduct in consideration of some compromise. However, a statutory right may also be waived by implied conduct, like by wanting to take a chance of favorable decision. The fact of the other side has acted on it is sufficient consideration. Milords 13-2, 13-4 had to be challenged when the situation then arise. Now, at the time of June sale notice, he can't come and ask, I did not serve in 13-2. So this judgment squarely applies. Milords in sales, and even that question, what he's asking, he should sit before DRT.
Only this.
Only this with respect of waiver and estoppel.
What about the first one?
Milords, first one is the alternative remedy. Milords, this after many cases.
Yes, I have seen this.
And he has chosen to go before DRT in the previous set of proceedings, the auction. Very same auction notice, very same rules, very same act is been
What
applied.
was question earlier in that essay?
Sale notice, the previous sale notice, just
He never no whisper about 13-2, 13-4 there.
no, same things he's telling there also. There also he's telling the 13-2 not issued, but in this judgment is applicable for DRT.
But you filed your objections in the essay?
No, Milords, the only prayer sought in that appeal was set aside of sale notice. When sale itself has not taken place, the petition is become infructuous.
Not, yes.
Not that, before that, no, I don't want to say
No,
that.
first of all, call your clients.
Yes.
Show it to them, whether there is signature or not.
1 minute, madam. This has been issued on 2019 notice, what he has produced now, in which that address is given as a BTM layout address. But what is the address has been given in the loan application is only the current petitioner's address is there. So on the basis of
They
that,
are referring to the signatures on the notice.
that I will check it right now. I will check.
May kindly compare those signatures to demand. He himself has produced MOTD.
I'll come. Now, apart from that, even if we assume the notice has
We will
been.
not assume anything.
1 minute, madam.
We have to know whether 13-2 notice is served on you or not.
The 13
Number one. Number two, earlier before the DRT, when the court has directed you to pay 60 lakhs, you come to this court and say, and the court ask him to deposit how much?
25
lakhs.
25 lakhs. No, this process you have to go before the DRT, whatever your claims under
I'll come
13-2.
before that. I want to make submission. I'll come back to that point. Now, what I wanted to impress before this court is the same properties e-auction notice was issued on 4/9/2025. In that, we are challenged before the SA in DRT. DRT has passed an order 29/9/2025, given an opportunity for the respondent bank to file a statement of objection, but they have not filed any statement of objection till 29/9/2025. Then 29/9/2025, after hearing the both parties concerned, the DRT presiding officer has passed an order subject to certain condition that 1 crore rupees to be deposited, not 60 lakhs. 1 crore rupees to be deposited within the period of 31/11 is the date is there for auction. So on that basis, in the shortened period, because I have not received the copy, I got it only after 6th. 6th immediately I moved. 7th is a court already. 8th was opening. So they kindly see that petition. Can you see that file before this?
Don't have to say.
1 minute, madam.
I will take your submissions as it
1
is.
minute. Then the court has given direction here. Can you see that? Will deposit 25 lakhs with the respondent, and for the deposit of remaining amount, he requires some time and he will deposit the same into 2 installments. The order passed by the DRT directing the petitioner to deposit 1 crore at a time is illegal and erroneous. Therefore, he prayed to set aside the order. Can you see page number 6, paragraph number 85, page number 85, paragraph 6. It is stated very clearly that the petitioner, instead of filing this petition, should have approached the DRT for extension of time and persuaded the DRT to extend the same. Since the time given to the petitioners to deposit 1 crore will expire today at 12 p.m. I filed it on 8th case. 8th is the opening. 8th I filed it. 9th I got it. 8th evening I served the copies. For that serving of copies, I have to beg like him. I have to beg to serve the copies. 1 minute, madam. I'll come back to that. Then after I serve the copies in the evening, then next day morning, the honorable judge passes the matter in the morning 10:30. Okay. Then this the time is granted. DRT is extended till 16/10/2025. Once this honorable court granted time till 16/10/2025, directing to the DRT, there is a question of closing the row at 14/10/2025. Because he made a submission that there was no sale happen on 11/10. So on the basis of that, he filed one memo. That memo is also not served on me. After that, I pressed the court and he sent it after 2 days. Then even though the case has been over on 14/10, become infectious. I want to say that because this honorable court granted 16 time, there is no question of the presiding officer to go and close the issue on 14/10/2025. My first point so far. Then we paid in your direction passed by this honorable court. Then I paid 25 lakhs on the same day. On 9/10/2025, when supposed to be the e-auction sale to be conducted at 11 o'clock on the same day. That we have paid it. Kindly see that the annexed.
Paid, we'll take it. No, nothing to see.
Annexed.
Paid the amount, 25 lakhs, we will take it.
That's only well as I paid it. Now, this notice, I'm coming back to this notice, impugn notice, which has been dated on 15/10/2025. But sale to be, e-auction sale to be ended today at 11 o'clock, 3/31/10/2025. So then the intensity it has been issued. 14/10, they have closed it. 16/10, order has been passed by this honorable court. And 15/10, you see that attitude of the bank people, 15/10 has issued this notice. They would have waited after wanted to go and approach on the basis of that notice which has been sent through the WhatsApp on 21/10. Even section says very clearly, 15 days time is required in case go for second. I'll read that particular section.
I'm aware of the.
So the section rule says very clearly, then rule 2 says very clearly, 15 days time to be notice to be issued to the borrower. But I got the notice on 21/10/2025 through WhatsApp. That is that in WhatsApp. So from 21/10, if we were calculated also, 15 days time, it comes only 36. That is on 5/5 or 6th it will come. 15 days. Now the auction is making it on 31/10. So what is the purpose of making it? In the meanwhile, after receiving that notice through WhatsApp, we approach the administration office in Tumkur. I met president as well as CEO. CEO said, you pay the principal amount of 1.25 crores. And regarding that interest amount, if you send a letter to us, we will put it before the board resolution. Board resolution once in 15 days to be conducted. Then we will hear the matter only regarding interest matter. Will you pay that 1.25 crores? I will accept it. They were saying that. So for that money, I'll come immediately here. I filed it on after I went on Saturday. On Tuesday, I filed it case. 28th, 29th, I moved before this. 30th, yesterday has come. 31 today. So humble request before this honorable court is, party is ready to redeem the property and is ready to willing to pay the pay of capital amount of 1.25 crores. Now 9/10/2025, 25 lakhs we have paid. We have paid it. The balance only 1 crore is there. If this honorable court permitted me pay that.
Already when once the DRT said you pay 1 crore, you didn't pay.
25 lakhs I taken from the permission of this court.
Now why should when this court says 1 crore, what will you do?
I wanted to extend the time. Meanwhile, that e-auction, I gone there for extension.
First of all, what is the business of this court to interfere in all this? You have taken the loan right from 2019. You have not paid anything.
We have paid. No, he never said it. I paid me up to 2018. 2019 COVID situation come. 2020 material tax. 1 minute, madam. 1 minute, madam. He material accident. He went on coma stage. He went on coma stage. My submission is, my last submission is, I am ready to pay that 1.25 crores within 15 days from today. Within 15 days from today.
This is what is the tax?
Definitely, if fails to do that, then bank will be taken the coercive action.
Can't do. And for what you are litigating for that 1 crore rupees? Then DRT order on that day was a good order. Why did you question it before this court?
Yeah, correct. But why did they want to close the e-auction? You will actually conduct the e-auction sale 14/10. They are not conducted.
No illegality.
The illegality is that illegality is this notice to be submitted in 15 days. That is illegal.
The DRT will take care.
1 minute. Now today's sale is there. I am ready to pay the amount.
The jurisdiction is the DRT, but still you come to the court. That doesn't mean that court will pass some order or the other.
1 minute. Before going to that, whatever judgment he has produced, each and every facts of the case is different to that judgment. And Article 226 says 1 minute. Article 226, 227 says very clearly, this honorable court having extraordinary jurisdiction to control the
Supreme
lease.
Court said you
To
don't
control,
have.
1 minute, madam. I want to pay only 1.25 crores. Kindly see that. 1 minute, only two sentences will make it,
Yes.
not more. Kindly see that impugned notice, page number 88. On negative, you will see. See, in this is 3.3 crores 88 lakhs 47,445 as on 34/2019. The present outstanding on 5 crores 52 lakhs. But I have to do the back only to the 1.25 crores as principal amount. The principal amount 1.25 crores has increased to 5 crores and two properties. Kindly say one more. This is previous notice.
All
1 minute,
those-
my lord. These are
all-
illegality what made by them. Kindly see
I
that.
will not consider, even if
No,
there is
1 minute.
illegality, go to the DRT.
No, I will, whatever our court order passes, that I will obey that. I'm not going, but I want to make submission to the extent
I'm
of
not inclined
what
to
they want
consider all
done.
those
Kindly
submissions.
see that, kindly see annexure E,
Not required.
page number 66, my remember.
Yes.
1 minute. Kindly see that. Then we'll come to know what is what. Page number 66, 12/12/2004 notice, e-option sale notice is issued for the two properties. The two properties, item number 1, item number 2. Item number 1 is present scheduled property of this writ petition. Item number 2, which has been paid in 7 crores property value, fixed value is 2.45 lakhs. But 2.45 lakhs, no bidder has come. Only one bidder has come. After that, in that property has been sold for 2.46 crores. 2.46 crores. Kindly see the annexion, next annexure, sale executed, sale certificate has been executed, which has been challenged before this honorable court. This is also pending before this honorable court. This may be likely to come before this honorable court only, before your honorable judge only it will come after 2 weeks. One. Next question is, then this matter, other than 2.5 crores has been fixed reserve price. This property, kindly see that impugned notice. What they said is 1.9 crores has been fixed. See that how the value will be come down from 2.5 crores to 1.9 crores. Let them say that. One. Second one is, my property is purchased in 2013 for 1 crore 15 lakhs. 2013. We approached the bank for loan for 2014 and they sanctioned loan for 1.25 crores for this property. 1.2 crores in 2014. Then what will be the value on 2025? Is it be reduced from 1.9? Absolutely, this is a mistake on the part of the bank. I don't want to say that point it is illegality or illegality, whatever it may be there. Whether I have to go to DRT or DRT or Supreme Court. But this honorable court having a jurisdiction to entertain this writ petition on the basis of this is all thing. Illegality, legalities will be there. This illegality is made by the bank. He wants to suppress. He is not arguing the matter so far this value of the reserve price is concerned. He come and say that an alternative remedy, just go to that. We know that. We know whether you have to go to alternative remedy or not. But whether illegality or legality to be found out, whether you have to come because this honorable court having enormous power to find out whether the impugned notice is legal or illegal on the basis of what is the reserve price and 1.25 crores again. 1.25 crores have to pay, but 5 crores have to pay for interest. Is it interest on made interest on calculate on the interest? So my humble request, I'm ready to pay. When I gone to the president, he asked me to pay 1.25 crores. I'm ready to pay the 1.25 crores. I'll pay. I'll give the undertaking affidavit also before the honorable court. I'll ready to pay the 1.2 within 15 days from today. Let them defer the sale or confirm that defer not to confirm the sale. There is only the two options for not. Because I'm ready, because this value more than 4 crores. Now they wanted to knock out the property 1.199. If any bidder make arranged by themselves, but 2 crores, then I'm losing another 2.25 crores. And apart from that, I have to pay the interest amount also. So whatever money are going to sell in the auction sale today, whoever buy this property for this property 1.9 or 2 crores, I am ready to pay that 2 crores within 15 days. Even that also, I'm ready to do it. So my humble submission before this, I am ready to pay 1.25 crores. What they promised, what they told us in the by CEO as well as president. I myself gone. I have not sent the party. Both of us went directly to go and met them. This notice has been issued by them. Then I want to take redeem the property. So I requested them. They said, okay, go and pay that 1.25 crores to the bank. Then rest of the things, send a letter. I'll put it before the resolution. then we'll come to resolution. I'll pass in how much in the waiver of the interest, we'll do it. So I'm humble request, 1.25 crores, I'm ready to pay within 15 days from today. Kindly defer the confirmation of sale. Let them conduct the sale also. I'm not worried. Defer the confirmation. One. Second one is, I am ready to pay that whatever money, whatever the sale is going to do it by them today. That
What were
amount
you-
I'm
what-
ready to pay within.
What were you doing till now?
I'm
From the
ready.
last 6 years?
Hmm?
From 2019 till 2025? What are you doing?
No, that's what I told you. The medical insurance only problem. Because he met with accident, he went to a coma stage for 6 months. That I stated in the representation.
5 crores, 23 lakhs.
Then your CEO said he'll
All-
settle it for
what all-
1.5 crore.
Everything is false. They just went, they declined their one-time settlement proposal offer. They did not even.
No.
Everything
this
is false.
no,
I have
no.
instructions today
Hey,
morning
let
also.
them come and say that. Let
I'm
them
not
file
denying they
affidavit.
went. They requested, they went and they wanted to pay only 1.25 crore, which bank told no. I have to recover 5.25 crores. If I sell the property, I'll get 2.25 crores, almost 2 crores. So they declined, they declined.
1 minute, kindly say annexure C.
One thing, what you say is about the notice. 15 days prior notice is not there.
Absolutely it is there, my lords.
What is the
Absolutely
date?
it is there. But yesterday only this court directed me to issue demand notice and position notice. RPID would have been sent. Whether that, let him file appeal before DRT, my lords. We'll answer all, we'll
No,
demonstrate before DRT everything.
Today's sale is
Let me
at
complete,
11
sir.
o'clock.
Please let me complete.
11
You
o'clock
are-
sale
you
is
not
there.
disturb you.
11 o'clock, 11:10 is going on.
Not, sir. If you let him file. Last time he had filed appeal before DRT. Absolutely it is there. Same witch hunt what he did for telling the demand notice is not served. Same similar submissions are made. I have RPID receipt. Paper publication is done. Newspaper publications will be done. No bank will sell the property without notice to the borrower. That he can question there. Last time he questioned there. I don't know what is the reason. He has not mentioned any.
Just one
He
submission.
should mention reason as to why he is bypassing the alternative remedy to file a writ petition before this.
No bypassing or anything. It is illegality on the issue of,
Already
illegality on the issue of this impugn notice, which has been dated
demonstrate everything. Let
15/10,
him file
but
appeal
which has
before
been
DRT.
sent to me through WhatsApp on 21/10. From 21/10, 15 days time is required for sale. How can you keep it date today on 31/10? How can they keep it on today's 31/10? Even send the WhatsApp on 21/10. I got that copy. They send it from the bank. 21/10 it is there. Then 21/10, 15 days time is as per the rule.
If it is
Sir,
right,
Rule 9.
what he's saying is right. Let him file appeal.
Then
Sale
if
will
it
be
is
set
judgment,
aside.
it has to be accepted.
If you are not given him notice, it's irregularity. Sale will be set aside.
Why come here? That's why I come here, illegality. So my humble request before all, that's the only thing. I'm ready to pay 1.25 crores within 15 days. I'm filing, undertaking, no problem at all. In case, if files to do that, let them do the coercive act. I cannot say more than that. Only for that, because this property, hard-earned property, that the value is more than 4 crores.
The
So-
presented petition is filed. Seeking the
I file
following-
affidavit also, my lord.
Seeing the following prayer. I am relegating you to the DRT. I am not passing any order.
Yeah, my lord, DRT, 1 minute, only 1 minute. DRT, that won't pay deposit 25%, they may ask us to deposit.
When you're ready to
That's
do
what,
it here,
that
that will-
25, that's what I'm requesting this honorable court. I'm paying entire amount of principal, what they promised.
they have not promised anything.
They have told us
Whatever
very
is your,
clearly.
whatever is your conversation with the bank is not the concern of the court. The bank counsel is here. Whatever he submits on behalf of the bank, that only this court will consider.
Correct, that's why I'm requesting them, ask them to
Then
file,
he-
I will
they
ask
said-
them, I'm requesting this honorable court,
He's
let them
submitting
file
on
affidavit.
instructions.
Let
Why
them
he should
file.
file an affidavit? He says on instructions.
No, he says it is not correct, but I'm saying it is
I will
correct. I
record- I
myself
will
has
record-
gone.
I'll record
He's
both
not
your
come. I
submissions.
myself was there present
The
before the
presented
meeting.
petition is filed.
And I'm requesting this honorable court, only thing, I'm ready to pay 1 second, man.
I will not.
I am
Mr.
15 days time
Counsel.
required.
No,
Yes, because now 1 minute,
not
1
on
minute.
1.25. 15 days time on the entire amount of 5 crores what
The
is
entire amount of
outstanding.
5 crores cannot be, because they promised 1.24 crores are ready to pay it. But
Then
what is
why,
what,
if they have promised you, why their counsel is not submitting that?
that's why they are not filed it, because they are not get the
Sir,
information, they are not
he has
instruction.
instructions.
That's what on the basis of the file affidavit now, or CEO. He told me in front of, across the table, he told me.
For that,
What
they
else
don't
I
have
want to do
file
that?
an affidavit.
I cannot take any videograph or anything.
Please,
So only thing is, my lord, this property is only property.
counsel, I am not going to grant any
Humble-
privilege. Please understand.
Humble submission. Now, 1 minute, my lord. 21, that given that WhatsApp.
I will record all that.
15
I'll
days.
record all that.
One minute,
That there is
1 minute, my
illegality
lord.
in issuing the notice.
1 minute. 15 days time is from the date we calculated, 5th or 6th will come. I'm asking another 1 week time from the 6th. That's for 15 days from today.
What will happen?
In case it is not happening, let them conduct the sale. Or definitely, let them sale conduct today. I am not coming in the way.
The sale that is conducted, if on your grounds, if there is an illegality, the DRT will set aside that.
One minute, my lord. Let them, I'm
This
coming to
court
the.
cannot set, do
Yeah,
all
I'm
that.
coming to the extent also. Instead of going to that, I'm coming to the extent, I made a submission, I filed affidavit before this honorable court for 1.25 crores, I'll pay it within 15 days. Let them conduct the sale today or defer the confirmation of sale in case if we not paid it. But only the calculation of time is important. Calculation of time. Tomorrow they will come and say that there's something there. But my humble request, because the illegality come on the naked eye, it's showing that the rule says very clearly 15 days time is required. Now the 15 days time is not yet over. How can they conduct the sale on 31/10 today? So my humble request, let them conduct in case if the court
I
feels.
think every submission of yours, you've
No,
reiterated
no,
10 times.
I'll
I
file
understood
affidavit.
everything.
Sorry, I'll file affidavit.
How
my
does
lord.
it
To the extent of
matter if you?
1.25 crores, I'll pay.
I'm not going to grant any interim order. I'm
Or
very
25,
clear.
or 25%, I'll pay it within 1 week. Rest of that-
25% you can pay before the DRT, and you can hear your DRT can apprise all your, you can
yes.
apprise before the DRT, all these things. If it is set aside, the sale is set aside, it's fine.
No, honorable. Sale, when the sale has been conducted today, and the sale certificate may be issued immediately. Then I'm not in position to go on, there you will come and tell it become infectious. The same word,
Here, I'm not keeping it pending.
same submission
I
made
am
before
not
this honorable
keeping
court.
it pending. I'm disposing it off.
One minute.
Relegating
The
you to the DRT.
same submission made before this honorable court, before this honorable court on the day on 9/10, the court has said, better you want to see, go and see before the DRT. For them. In fact, he himself said that before this honorable court, become infectious in case we have done it. If it has been stayed, it's become infectious now. So you go and say before the DRT. Then DRT has given the deadline, I extend the time. I'm requesting, I'm humble request because the property to be saved. Yeah, well settled, Supreme Court law says very clearly, parties are having ready to redeem the properties any time after paying necessary interest or whatever it may be. But I'm humble because I myself am gone. I'm not sent somebody policy. I don't send, in case this court feels to that, I let them file affidavit. I am only the 31.
Pass the order in the chamber. He's not letting me.
Well, I'll let him, my lord.
I will not grant this.
I'm having the affidavit also filed before this court.
The pass order in the chamber.
Obliged.
Dismissed.
Kindly pass an order, madam, no problem. No,
Pass
I
the
don't
chamber.
interfere.
Giving liberty to the petitioner to avail the alternative remedy. Yes.
What, ma'am?
Giving liberty to the petitioner to avail the alternative remedy. Writ petition is dismissed. Yes, next.
List number 2, serial number 1.
My lord, if I just.
Kindly pass an order, madam, I will wait. I'll pass for it, kindly pass an order, I will wait. No problem.
Same order and pass in the chamber. How does it matter?
Yeah, no,
I'm
in front of my
dismissing
own,
it.
I can.
Yes, do that.
Please.
The writ petition is fine. Volunteer. Okay, order sheet. Writ petition is fine. Seeking the following prayers. It is stated, the facts of the case are that petitioner number 1 has purchased the scheduled property in question by sale deed dated 6/5/2013. And they have availed by mortgaging the said property, they have availed a loan of rupees 1.25 crores on 5/9/2014. It is stated that the petitioners have been repaying the loan from 2014. Due to COVID, they have incurred huge losses and they could not repay the loan. In the year 2000, during the year 2019-20, the petitioner met with this accident and had been admitted in the hospital. And he is not able to repay the bank loans. The petitioners have filed several representations on 22/5/2025 to different branches and to two final representations filed on 21/6/2025. Even though the respondent bank had not given any opportunity and also no response from the respondent bank for the petitioners to settle the dues with the respondent bank. it is stated that the petitioners want to settle the dues. When the bank has issued a e-auction notice dated 4/9/2025 through WhatsApp on 6/6/2025 to one of the petitioner's mobile number, in which e-auction is sale notice, the respondent bank by affixing the sale on 9/10/2025. The notice was not delivered to the petitioners by the respondents through the mode of Indian Postal Department. In the notice, it is stated that the outstanding amount as on 2/9/25 is 5,63,24,620, which is not correct on the part of the bank. And in the notice, it is stated that the total amount due payable by the petitioners as per the agreed terms and conditions is rupees 3,88,47,445 as on 30/4/2019. It is stated that the amount has been recovered by the respondent bank in the earlier auction notice, e-auction notice dated 5/3/2025 for different properties. And the said property had been executed through the sale certificate to its certificate on 5/3/2025. The bank did not disclose the fact that whatever amount has been recovered in the earlier e-auction sale notice not been deducted from the total outstanding amount. The petitioner has challenged the e-auction notice dated 4/9/2025 before the DRT in SA number by filing SA number 334 of 2025. The tribunal was pleased to pass an interim order in SA number 334 of 2025, where the auction was stayed on a condition that the petitioner shall pay 1 crore on or before 9/10/2025 on the date the auction was fixed. The petitioner has carried this matter to this court by filing WP number 30478 of 2025, challenging the interim order granted by the DRT in SA number 334 of 2025. Then in that, an interim order was passed. Directing the petitioner to pay 25 lakhs before 5 p.m. on 9/10/2025. And the time is extended till 16/10/2025. And accordingly, not interim order, a final order is passed. It's not an interim order, final order is passed. It is submitted that as per the order passed by this court, they have deposited an amount of rupees 25 lakhs. The DRT has fixed a date for hearing on 14/10/2025. On the day the SA was closed, as the e-auction sale, the e-auction could not be held on that day. It is submitted that they have not received any notices, including the e-auction notice dated 15/10/2025. And the notice is not sent through the speed post, but it is received by them on 21/10/2020 WhatsApp of one of the petitioner's mobile numbers. The notice is defective in nature. And again, the petitioners are disputing the outstanding amount. The respondent only to wreak vengeance and with a deliberate attempt to cause hardship to the petitioners. They have issued the e-auction without an issuing 13-2 notice or 13-4 notice Hence, the petitioner, having no other alternative remedy, not alternative and efficacious remedy, has come before this court. The interim relief that is sought further, it is in support of the grounds. It is stated that the action of the bank in issuing the auction notice is contrary to the Surface Act 2002 and the rules. The bank has totally violated the procedure prescribed under the Act, and they have illegally invoked the provisions of the Securitization Act. The bank has failed to comply with Section 14B1 and subsection 8, Roman 8B of Section 14 of the Act, and it is not in accordance with law. And they have failed to calculate the date of NPA. They are proceeding to auction the scheduled property below the market value and the guidance value of the government without obtaining the valuation report of the property. In view of these circumstances, the auction notice needs to be set aside. Next, learned counsel appearing for the petitioner submits that the petitioner, he along with the petitioners have approached the CEO of the bank. This is next para. CEO of the bank, and they've said that the CEO has assured that if he pays an amount of rupees 1.25 crores, they will settle the amount. Learned counsel submits that as the entire procedure is contrary to the provisions of the Surface Act, the notice needs to be set aside, and that apart, they're ready to pay the entire amount, the amount of 1 crore 25 lakhs as assured by the CEO within a period of within a period of 15 days. As such, the auction may be stayed. Then they will approach the DRT, and at this point of time, approaching the DRT is not an effective and alternative remedy. It is submitted that due to financial conditions, the petitioners could not repay the loan. Now, if as there is clear violation of the statutory rules under the Surface Act that made the petitioner to come before this court, it is submitted that in those circumstances, the court, though there is debt recovery tribunal, still this court can entertain the writ petition and entertain the writ petition. Hence, the learned counsel for the petitioner prays that there shall be a direction to the respondent not to conduct the auction. Next para. Learned counsel appearing for the respondent bank.
The permission, I can say one has been missed here when dictating. On 12/12/2004, the notice has been issued for two properties. One property sold for 2.46 lakhs, 2.46 crores. That amount has not been whether recovered or it has not been adjusted.
That I have already dictated.
It is not coming.
Dictated. I remember what I have dictated. You must not.
They call same 3 crores 88 lakhs. Value has
I have
been put
recorded
it.
that according
Now,
to you, it is
after
not
deducting that amount, at least the amount will be come down, no?
Yes.
That's what.
The respondent bank. Then counsel appearing for the respondent bank submits that none of the submissions that are made before this court or contrary, all the submissions that are made before this court are contrary to the record. It is submitted that they have followed all the procedure. They've issued 13-2 notice. They've issued this 13-4 notice, and it is duly served on them. The petitioner has placed before this court the the notices, the postal receipt, and also the acknowledgement to show that the notices are served, and also acknowledgement and the notices are served as long back on 1/11/2019. Further, he has placed before the court the paper publication and the possession notice. It is submitted that when the petitioner has questioned the earlier sale notice before the DRT has directed him to pay an amount of rupees 1 crore. He has come before this court and the same was reduced to 30,000, 30 lakhs, 25 lakhs. The petitioner the liberty was given to the petitioner to go to the DRT. It is submitted that the loan is due, the proceedings were initiated in the year 2019. Except this 25 lakhs amount, as per the order in the writ petition, no other amounts are paid by the petitioner. If there is any irregularity in conducting the sale, in issuing the notice, if 13(2), 13(4) notices are not issued, all these grounds the petitioner can raise before the court, raise before the DRT, and DRT would be effectively adjudicating the matter. The learned counsel for the respondent bank further submits that, as per his instructions, when the petitioners have approached the respondent respondent, that they are ready to respondent that they are ready to pay an amount of rupees 1 crore 25 lakhs. The bank has rejected the said proposal, and his instructions are bank is not ready to accept that 1 crore 25 lakhs amount as one-time settlement as offered by the petitioner when the outstanding as on 2019 is through 3 crores and odd. 3 crores and odd. And
Not only offered, they themselves offered to us.
it
Not
is
I am
that they have
asking,
not
they themselves
offered.
offered
The
1.25
bank has not
crores.
offered 1.25 crores. And when the outstanding itself is 3 crores and odd in the year 2019, and now 5 crores and odd, the bank has not come up with any of the said proposal, and it is submitted on, he has instructions in this regard from the bank. Learned counsel submits that from 2019 till now, the bank could not even realize the note, and he relies on the judgment of the apex court in PHR Invent Educational Society versus UCO Bank and others, arising out of SLP civil number 887 of 2022, a judgment of the judgment of the apex court dated April 10, 2024. He submits that the Honorable Apex Court in the said judgment has categorically held, by considering various other judgments of the earlier judgments of the Apex Court, that a petition under Article 226 of the Constitution could be entertained in spite of availability of an alternative remedy where the statutory authority has not acted in accordance with the provisions of the enactment in question. It has acted in defense of the fundamental principles of judicial procedure. It has resorted to invoke the provisions which are repealed, and when an order has been passed in total violation of the principles of natural justice. He has also relied on the judgment of the Apex Court in case of ARCE Polymers Private Limited versus Alpine Pharmaceuticals Private Limited, reported in 2022 to SCC 221. He has relied on paragraph number
12, 13.
Paragraph number 12, 13, 15, and 16, and 17. Extract these paragraphs. Relying on this, learned counsel submits that the petitioner has approached the DRT at the earlier point of time. And these 13.2 and 13.4 notices, the aspect that these notices were not issued to him was not questioned before the DRT, and he has relinquished the right. When the matter has come up till the stage where the auction notice is issued, at this point of time, it is not permissible for the petitioner to raise all those grounds which he has waived and relinquished. It is submitted that in the light of the settled law, the interference of this court under 220 under 226 is not permissible, and the petitioner shall be relegated to the DRT. Next part. Having heard the counsels on either side, peruse the material on record. In the judgment, in the case of PHR Invent Educational Society, the parameters that are laid by the Honorable Apex Court with regard to the interference of this court in a matter pertaining to securitization in Surface Act are very clear. When the whole purpose of constituting the tribunals for a specific claims is for the purpose of getting a timely justice to the parties. The petitioner admittedly, right from 2019, he has borrowed the amount in the year 2014. Right from 2019, he has not paid any amounts till an order is passed in the writ petition in the year 2025. Only an amount of rupees 25 lakhs is paid. The grounds that are raised, prima facie, this court is not able to appreciate about 13.1, 13.2, 13.4 as the prima facie, the material that is placed before the court shows that the notice is served on the respondents way back in the year 2019. From the year 2019 till he approached the DRT by filing the SCA, what was the petitioner doing is nothing is forthcoming. And with regard to the outstanding 1,25 lakhs that they have given the offer according to the petitioner and according to the learned counsel for the bank, such offer was not given. Now, with regard to the irregularity that has taken place in an earlier sale, it was always open to the petitioner to question it, that there is a fraud played by the bank, if according to the petitioner. But that was not questioned by the petitioner, and he kept quiet. All those things are not open for this court to consider. Then the petitioner submits with regard to the sale, the sale notice, the 15 days timeline and all. Even the learned counsel for the respondent submits that they followed the procedure. If there is if the procedure is not followed by the bank, it is a fit case for the petitioner to approach the DRT, and the DRT would set aside the sale, considering all other relevant factors and for the purpose for which such tribunals are constituted. In the considered opinion of this court's interference in a writ petition of this nature is most unwarranted, and the petitioner shall approach the DRT accordingly. This court is passing the following order. The writ petition is dismissed, however, giving liberty to the petitioner to avail the alternative remedy.
1 minute. Yes, liberty given to me to go to the DRT. I'll go, but till then 15 days time to be required to file before the DRT, and the defer of the sale will be there.
All that you
Because
can ask the
what will
DRT.
happen now, if a sale has been conducted today, and if the next day tomorrow, if not filed, because 45 days is required for filing on e-auction sale notice. 15/10/2000 notice onwards, 45 days is there to go and approach the DRT. Now 31/10/2010, if the sale today is conducted the sale, and tomorrow there may be sale certificate may be issued.
Please understand.
So what will happen?
Please understand.
I record only to that part I record, not more than that.
there is any illegality in the manner in which they are conducting the auction, it is always for the DRT to put everything at naught. So whatever that takes place, the DRT will put it back to the state. So nothing, we will not interfere in this unless the court is convinced.
The only thing is that one word on the sentence to be added only, my lord, with the request. I'll approach it. Till then, they are not deferred the sale. That's all. Let them not confirm the sale of that.
What is not directly that is given, now by way of this prayer, you can't indirectly ask it.
Once not directly getting it, cannot come back.
Please understand, Mr. Counsel, that's not the way this court is
I want for this one thing. In 26/2025, Supreme Court in order, recently has passed an order regarding to that Article 226 and 227 of the Constitution of India, again the same DRT matter, surface matter. This honorable court having enormous power stated there, but I have not taken it.
No, I know,
Recently has given, just 10 days back.
This court has got the power in exceptional cases, in which your case will not fall under this case.
No, that's not because.
For the next matter, already I given you enough time.
Yes. Orders matter, sale number 1, Omkar KT, appellant.
My lords, I apologize.
What happened to that matter?
End of list. Petitioner counsel is here, my lords.
Where is he?
Sorry, morning did not apply. Right?
Okay. We'll pass order.
Please, Lord.
Yes.
Sale number 1, this one.
First matter.
First matter.
Yes. The present petition is filed seeking the following prayer. The interim prayer that is sought is to stay the operation of the public notice issued by the respondent number 3 authorized officer of the SS Care and Reconstruction Enterprises Limited to conduct the public auction of scheduled property on 27/10/2025. The facts of the brief facts of the case are that on 13/8/2018, petitioners have availed the housing loan of a sum of rupees 1,36 lakhs. What is that?
7,886
lakhs?
7,882 rupees.
7,882 from the respondent number 1 bank. It's called, what is this, bank or finance company?
Finance company.
From the respondent number 1 finance
Non-banking
company
finance company.
for a period of 15 years at the rate of interest is 12.60% per annum. It is stated that the petitioners have regularly paid the EMI, and in the month on Jan-Feb 2024, petitioners have paid a sum of rupees 95,50,000 to close the entire loan. On 28/3/2025, the respondent number 1 finance company has transferred the loan account to respondent number 2 Asset Care and Reconstruction and received a total sum of rupees 55,22,522 from respondent number 2 in September 2025. Then they have issued the respondent number 3 has issued the auction notice to be scheduled on 27/10/2025, declaring the reserve price at rupees 1,49 lakhs in spite of receiving asset under much lesser value with the intention to make willful gain. Questioning that no notice, the petitioner is before this court. when his outstanding loan is 55 lakhs 22,000, when the outstanding loan is 55 lakhs 22,522, but the reserve price is as 1 crore 49 lakhs, that itself clearly shows the intention of the bank to defraud the interest of the petitioner. It is submitted that the loan is a home loan and the respondent cannot make a profit on the losses of the petitioner. The petitioner is ready to pay the entire consideration amount of rupees 55 lakhs 22,522 along with 10% additional amount. He submits that in the light of the law laid down in Salil R. Uchil versus Vishnu Kumar and others, the court may pass an order. The reserve price of rupees 1 crore 49 lakhs shows that that they have they are claiming double interest, which is clearly in violation of the RBI guidelines. Hence, they sought stay of the auction. When the matter came up on on 28/10/2025, considering the argument of the learned counsel that the asset reconstruction company, that is the third respondent here,
Second and third respondent.
second and third respondent herein, when the debt was assigned to them, when the debt of 55 lakhs is assigned to them, and when the petitioner is ready to pay an amount, the borrower is ready to pay 55 lakhs. Now the reserve price, that is 1 crore 49 lakhs. When it is stated that the reserve price is 1 crore 49 lakhs, this court this court has specifically asked the second and third respondents, why, when they are ready to assign this debt to the second and third respondent for 55 lakhs, why not the bank give the same offer to the petitioner? And when the debt is assigned for 55 lakhs, why the reserve price is running into 1 crore and odd?
Well, it's the auction notice also has the outstanding. There's a similarity in price.
No. The order on 28/10.
About.
Then this court has directed, then this court has orally directed the respondents not to confirm the sale and permitted the petitioner to serve the hand summons on the bank and listed and directed the matter to be listed on 30/10/2025. When the matter came up on 30/10/2025, the learned counsel for the respondent 2 and 3, led by the senior counsel, has placed before this court what is the date? That
It's the assignment agreement, my lords.
dated
25/3/2025.
Yes, ma'am.
25/3/2025.
28 March 2025, my lords.
25/3.
28 March
2025. 25, whereby by the said assignment deed, as many as
168, my lords.
168 loans are assigned to the asset reconstruction company. Learned senior counsel submits that this document they cannot file before they cannot serve a copy of it on the respondent. However,
On
for
the
the perusal of the
petition.
on the petitioner, for the perusal of the court, they have placed it before the court. And this court has perused the said document, as rightly submitted with the learned senior counsel. The in the entire, in the said assignment date, there is no mention about 55 lakhs as submitted by the petitioner. Further, the petitioner has argued that once the debt is assigned to the asset reconstruction company, they shall issue the notice. They should negotiate with the borrower again, and then only they can proceed with the matter. In response to that, the senior counsel submitted that when the debt is assigned to the asset reconstruction company, they will step into the shoes of the bank, and the proceedings will roll from where it stopped. Not necessary that they have to go back. It is further submitted that none of these grounds are raised in support of the writ petition, and now the petitioner, without any basis, assuming that an amount of rupees 55 lakhs, for an amount of 55 lakhs it is assigned, has come before the court. It is submitted that the outstanding as on the date of auction is
1 crore 43 lakhs, 22,694.
1 crore 43 lakhs, you have written. So it is submitted that all the assignment of the debt and further assignment of the debt is done as per the RBI guidelines. If the petitioner feels that there is any fraud that's played by the bank in assigning the debt to the second and third respondent, he can file a appropriate complaint to the RBI. It is further submitted that on these grounds, if the court interferes, then it would be very difficult for the financial institutions to recover the amount. Then senior counsel submits that absolutely there is no illegality in assigning the debt to the second and the third respondents. Next part. Having heard the learned counsels on either side, there is the material on record.
My lords, if I may request for 2 more submissions to be recorded, which was one that the alternate remedy is there under section 17.
Learned counsel submits that there is an alternative remedy to the petitioner to go before to approach the DRT, questioning the sale notice, e-auction notice or sale notice. What is it?
It was the e-auction notice.
E-auction notice that is issued by the respondent, and he has not pointed out any of the grounds seeking interference of the court by bypassing the alternative remedy available to him.
And our second submission, the final prayer is a right of redemption. We had submitted that it ceases immediately upon the publication of the e-auction notice.
It is further submitted that the reliefs that are granted by the relief that are sought by the petitioner is redemption of the mortgage. In the light of the settled law, the moment an auction notice is issued, the borrower will lose the right of redemption of mortgage, and such a prayer cannot be considered unless and until the sale is set aside on the ground. Sale is set aside. Next part. Having heard the counsels on either side, peruse the material on record. The prayer as sought for by the petitioner when the matter came up on the first day, this court is not convinced on the reliefs that are sought and the interference of this court under 226. When the petitioner has argued, stating that the debt is assigned, that is at 55 lakhs, and they're selling it for an amount of a reserve price of 1 crore 49 lakhs. Then this court has specifically asked the respondents, and on that ground, this court has already directed them not to confirm the sale. After the assignment date is placed before the court, which makes it very clear that the submission of the petitioner that the debt is assigned at rupees 55 lakhs is not correct. And further, the grounds that are raised by the petitioner, which is already discussed by this court in the preceding paragraphs, None of those grounds are raised in the writ petition. Then coming to the question of redemption of mortgage, the moment the notice is issued by the respondent, the auction notice is issued by the respondents, the petitioner will lose the right of redemption of mortgage, which cannot be considered by this court, which cannot be granted by this court, unless and until it is held that the sale notice that is issued and the sale that is conducted by conducted by the respondents is bad, and the same is set aside. And with regard to the conducting of auction and the notice and all other aspects, this is always open to the petitioner to approach the DRT, and the DRT will decide all these issues and all these issues. Hence, this court cannot grant the reliefs as sought by the petitioner. In the light of the same, the writ petition is dismissed, however, giving liberty to the petitioner to avail the appropriate remedy.
My lords, there's one
To approach
clarification.
DRT and or appropriate forum, your lordship. Liberty may be reserved in favor of petitioner to approach DRT or appropriate forum.
DRT the petitioner is at liberty to avail the remedies available to the petitioner.
My lords,
Legal remedies that are available in accordance with law.
My lords, as senior counsel had submitted yesterday, one clarification which is requested from the court is that the 25% was not taken based on the oral instruction. Now yesterday.
In the order, this court orally on 28 has directed the 28th November has directed October has directed the respondents not to finalize. When the matter came up on yesterday,
Yes.
30th, after hearing the learned counsel, senior counsel, and also looking at the assignment date, has permitted the respondents. Yesterday I said so.
Yes, my lords. The only reason is because what happens in these cases is there'll be a fresh challenge filed saying that the 25% was not taken within the 24 hours.
Yes. No, that's why yesterday itself I said it can be done.
Taken it, but that challenge still remains open because for that clarification.
The
can
respondent, then this court has permitted the respondents to accept the 25% deposit. Yes, next.
Much obliged.
Much obliged.
List number 2, serial number 1.
Lords, in similar matters listed on the other day, wherein the prayer was, there is an error in the prayer, my lord. I had sought for filing amendment application in those two matters as well. Same is the.
We have served the papers on them. That's
My
why.
lord, once the amendment is done, I shall do it immediately, my lord.
Learned counsel seeks permission to amend the prayer. The permission is accorded within a week.
Please.
The petitioner shall amend the prayer, or else the appeal shall stand dismissed without further reference to the court. Immediately after amendment of the prayer, the copies shall be served on the respondent counsels. Yes, delete from dismissal. Yes.
Cell number 2. Suresh M. Latur.
Ready? Yes.
Case of injury, my lord. Case of injury.
Para 13 of the judgment. Para 13 of the judgment we will look into.
The appellant has sustained type
No,
3B.
let's go to the table. Yes.
Type 3B open compound fracture of both
How many
bones of
fractures?
3 fractures, my lord. TB and fibula and left segmental TB also.
How much pain and suffering, Mr. Janardhan Reddy?
50,000 is awarded, my lord.
50,000 is awarded. Another 20,000, my lord.
My lord, 1 lakh may kindly be.
No. Next, how many days was in hospital?
9 days.
30 days, my lord. 30 days, my lord. 3 times he was operated, my lord.
Incidental expenses 30,000.
Yes. Loss of income during laid up period 3 months, my lordship. With another 13,500 is to be enhanced.
1 minute. Loss of income during later. Which year is the accident?
2012.
18, my lord. 18, my lord.
12,500, my lordship.
1 minute. 2000?
18, my lordship.
2018 is 12,000. How much the court had taken?
12,500 only.
Into will grant because his hospital itself in 30 days.
Yes, ma'am.
Another 4 months. So that is altogether 5 months.
Doctor has assessed in disability at
1
40.
minute. I have to complete this calculation.
Sorry, my lord.
62,500. Yes, then
Doctor has
Medical
assessed,
expense, please wait, I'll ask you.
please, my lord.
Medical expenses as it is. Then what about future medical expenses? What did the doctor say?
Doctor has assessed 48% to the particular limb and
Future medical
24%
expenses.
They have not produced the piece of document subsequently after that.
You know, what is the evidence of the doctor with regard to the future medical expenses?
My lord, he has said, my lord,
How much is required according to him?
he has not assessed, my lord, but he has proposed that he requires one more operation. my lord.
Another 10,000.
Only 10.
Without doctor's evidence,
Doctor evidence is there, my lord. It is
doctor's
here.
evidence with regard to what are the expenses
Expenses
for the future medical, future operation.
is, my lord.
So
But
it
he
is
has-
not there. So that's why we'll grant another 10,000. Then what is the disability according to the doctor?
That should be 45%.
48% to the particular limb and 24% to the whole body. The tribunal has taken 10%, my lord.
1/3 has to be taken into consideration.
Then it is-
15% is comes, but the tribunal taken 10%, my lordship.
It comes to 16.
Yes, my lordship.
Tribunal has taken 10.
10, my lordship.
So 12,500 into 12, what is the multiplier?
18, my lordship.
18.
18 into
16.
16. It's coming to 4,32,000.
Yes, my lordship.
Loss of amenities, how much is granted?
20,000 is granted, my lord. He was a mechanic, my lord. He cannot sit. And
The 20,000.
it is very meager, my lord. 50,000 mechanic.
There is a formula for everything. It's coming to 7,04,011.
0, yes, my lordship.
So from what we do is from November 10th, we will take this MFA matters on Thursday, Wednesday and Thursday till 2:30. After 2:30, I will, from after 2:30 on Friday, I will take family court matters.
Yes, ma'am.
So to complete this 1.5 day for this.
Witness stand.
The agreed by the orders passed in embassy number 7049 of 2018 dated 3rd October 2023. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees how much?
Ten lakh.
Seeking compensation of 10 lakhs for the injuries sustained by the claimant. The tribunal has awarded the compensation as per the table given below. At paragraph number 25, extract the table. When counsel appearing for the appellant claimant submits that the tribunal had failed to grant a reasonable compensation of the head of pain and suffering and incidental expenses. Then coming to the loss of income during the later period when the claimant was in hospital for 30 days, court had only considered 3 months. Further, when the evidence of the doctor is that he had sustained 48% disability to the limb, court ought to have taken 16%, but the court had taken 10% as disability. Further, for the disability of 16%, under the head of loss of amenities, only 10,000 is, loss of amenities, only 20,000 is awarded. Further, it is submitted that on all counts, the compensation needs to be enhanced. Land counsel, next para, land counsel appearing with the insurance company submits that the court has granted a just and reasonable compensation and there are no grounds to interfere. Next para, having heard the counsels on either side, peruse the material on record. The claimant had sustained 3 fracture injuries. Hence, under the head of pain and suffering, this code is granting 70,000. He was there in hospital for 30 days. Hence, under the head of incidental expenses, this code is granting 30,000. Then coming to the loss of income during the later period, considering the fact that he is there in the hospital for 30 days, 12,000, this code is inclined to consider 5 months, 12,500 into 5, 62,500. Medical expenses as it is, and no interference is called for. Coming to the loss of coming to the future medical expenses, court had granted 20,000 and this court is granting 30,000. Then loss of future income. As rightly argued by the learned counsel for the petition appellant, the court ought to have taken 16% as disability. Hence, 12,500 into 12 into 18 into 16 by 100 is 4,32,000. For a disability of 16%, this court is granting amenities at 40,000, loss of amenities at 40,000. In the light of the law laid down in Mekala vs. so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for 7,04,011. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 4,52,011 to 7,04,011. Yes, the amount, the enhanced amount shall carry 6%. You have a format for this, you take it. Yes, next. Delay is there. IA number 1025 is filed to condone the delay of 53 days. For the reasons stated, the delay is condoned. Yes, next.
Sale number
No,
3.
how much is the delay? Not 53, huh? Already condoned, it's not required. I was looking at first case. Yes.
Sale number 3.
Before.
Shankar Reddy C.
Applied.
Yes. On what ground you are before the court?
Only quantum, no dispute with regard to the liability. And,
Case of death or injury.
injury. Doctor has assessed the disability at 18% to the para 37 of the judgment.
37. Huh. No.
The
Pain and agony, no dispute.
No dispute. Only future loss of income, only one ground, one head. Under this head, the amount is.
One minute. Medical expenses. As it is.
Medical bills as per.
1,32,000 to 20.
15 days he was inpatient.
He was in
15 days.
So, incidental expenses, 15,000.
Yes.
Loss of income during later period, no.
3 months. 3 months.
Income during later period, 36,000. What is the disability according to the doctor?
18% to the
Limb.
right lower limb.
How much was taken?
18% has been considered as whole body disorder. Only that.
It has to be 1/3. It has to be, then we have to take it 6%. Yes. So what is the income?
Income 12,000 has been considered.
Loss of, which year is the accident?
Accident 2020.
It has to be 14,500.
Yes.
Now we will take.
No problem.
So 14,000, it was court has taken?
Court has taken 12,000.
So we will take 14,000. Now it will compensate, I think.
Yes.
14,000. 2,000, is that 20 or 19?
14,500.
14,500.
1,35,720. I already calculated.
Calculated. Yes. 14,500 into 12 into?
13 into 6.
6. How it is coming to?
1,35,720.
1,35,000?
720 as against 3,36,960.
Oh, still it is less.
Yes.
It's because that 18% is what makes a difference. Then?
That's all.
Legal expenses.
Only one.
No legal expenses. Your appeal. Amenities?
And also one more ground, my lord. Rate of interest is 9%. That has to be reduced to 6%.
1 minute. Loss of amenities, 30,000. it's coming to 3,98,940, half of it.
Half of it.
Almost. Please come. Agreed with the award passed in MVC number 16 of 2023. Dated 13 December 2023. The insurance company is before this court questioning the quantum of compensation. The tribunal has granted the compensation as per the table given below at paragraph number 38. When counsel appearing for the appellant, claimant submits that, the appellant insurance company submits that, on all other, the insurance company is before this court only on 3 grounds. Number 1, towards incidental expenses, when he was in hospital for 15 days, court had granted 29,000. And when it comes to loss of future income, when it is evidence of the doctor that it is 18% disability to the limb, court had considered 18% to the whole body. The interest is awarded at 9%. It should have been at 6%. Next paragraph. When counsel appearing for the respondent claimant submits that the court had rightly granted the compensation and rightly taken the disability at 18%, and there are no grounds to interfere. Next, having heard so and so. The insurance company is only disputing on the 3 grounds which are discussed above. Incidental expenses, as he was in hospital for 15 days, from 29,000, it is reduced to 15,000. Coming to the loss of future income, when the disability is 8% to the limb, it has to be 1/3 to the whole body. Hence, this court is taking 6%. But the court, when it comes to the income, has taken 12,000. As this court is reappreciating the compensation, as this accident had taken place in the year 2020, this court is taking 14,500 into 12 into 13 into 6 by 100 is 1,35,720. Accordingly, the claimant is entitled to 3,98,940. The appeal of the insurance company is allowed by reducing the compensation from 6,14,180 to 3,98,940, and the rate of interest is 6% on the entire amount. Amount in deposit shall be forthwith transferred. Yes, next.
Number 4.
Today, we are very happy because the matters are reached before.
No, from 10th.
Yes.
Your matters will reach every day on Wednesday and Thursday.
Thank you so much.
My lord,
Yes.
I am for appellant in this case. It is a case of death, my lord.
Yes, Pradeep is here.
Yeah, I am ready, my lord. It's only one on account of loss of dependency, my lord.
That we will
Because,
see. Where is the table? Yes, Pradeep. What is-
Liability fixed against the owner of the vehicle. My Ladun friend also not challenged that pillion radar risk is not covered, liability only policy. They are seeking enhancement only against owner only.
Oh, nothing against, that you have not challenged.
No, madam.
Mr. Sabu.
Settled principle of law, my lord, they have not questioned also.
Yes. I think he is not even conscious of that fact.
No, my lord.
Then why is he not answering? You are
You
seeking only enhancement, and as far as the insurance company's liability is concerned, you have not questioned.
Hello, sir.
Yes, my
Make him
lord.
come physically. It's very difficult to hear him online. This is matter someday. Yes, next.
Cell number 5. Cell number 5.
That's for the respondent.
Where is Mr. Gurudev Prasad? No pass out today. Yes, this is matter someday after 2 weeks. Yes, 6.
Cell number 6.
There is one more connected matter filed by them.
List along with so and so on 12th of November. Yes, 7.
Number 7. Nagaraj Ekde. Ravish Benny.
For the second respondent, madam.
Lord, at the first instance, my lord, the claim petition filed by the, my lord, the claimant was dismissed. And thereafter, appeal has been filed before this honorable court. Insofar as, since the the claims tribunal has not passed any order on the quantum of compensation. Only on that aspect, my lord, the matter was remanded. The quantum of compensation has been considered by the tribunal, and that has been confirmed again by this honorable court in the very same appeal. Thereafter, my lord, matter has been remanded once again to consider the aspect of liability and the negligence. So far as the quantum of compensation is concerned, has been confirmed by this honorable court, and only in respect of consideration of the liability and the negligence aspect, my lord, matter has been remanded once again.
What happened now?
Yes, ma'am.
What happened now?
Now, my lord, there is a direction in the order passed by this honorable court to implead the driver of the lorry and owner and the insurer of the lorry, which is said to have been, the contention said to have been taken by the insurance company at the first instance. But in our claim petition, nowhere, my lord, it is said, my lord, due to the involvement of the lorry, the accident was took place. There was no mentioning about the.
What is the order? What is it you're questioning now?
Now, my lord, the finding given, but there was no operative portion in the judgment, insofar as the negligent aspect.
That is not what is the has to be decided.
That is what has to be decided. Only findings has been recorded to the effect that.
Look at the old order.
Yes, my lord. Old order at annexure C, my lord.
Page number?
Page number 63, 64.
May I submit, please, ma'am? It requires a TCR, please.
TCR.
No TCR, it
Call
cannot
for
be
the
disposed
TCR.
of.
Finally,
Kindly,
my lord,
appeals to
it may be
History is
received, my
valid
lord.
to call for the DCR.
It might have received, my lord, since it is posted for final hearing.
No, it's not that. So many matters are posted for final hearing without TCR.
They have shown as awaited.
Yes, next.
Cell number 8.
Yes, Mr. Shastri.
Claimant's appeal only for enhancement, my lord. The amputation of the feet, my lord. The tabular form is found in page number 13. My lord,
yes.
Facts in nutshell is 29 years person is a auto driver come owner. Well, to prove his ownership and driving,
No.
well, DLRC
Mr.
and photo.
Shastri.
My lord.
Mr. Shastri.
My lord.
Now, pain and suffering, any dispute on that? Already 1,20,000 is granted.
Well, normally 130, normally, but I am not coming the way of the.
What is that? Normally 130.
Normally 150, 1,50,000 to 2 lakhs is nowadays they are granting.
What is the case? Amputation of Ebony, amputation of Viloni, that's called, my lord. Lordship is granting 1 lakh. I don't know 1 lakh.
Anyhow, 120 will take. Then how many days was in hospital?
But he was inpatient in 23 days. First 1 day and thereafter 22 days. But there is an amputation of right foot. Loss of all the toes.
No. So incidental expenses, no enhancement is required. 70,000 court has already granted.
Amenities no
medical bills, that will go, medical bills. What we should do is, Mr. Shastri, first admitted, you should tell the court.
Yes,
Then disputed, we will go.
Yes, negatively, I am arguing only where this compensation is required to be enhanced.
Court has to write down.
Yes.
And loss of income.
My lord, I am
Loss
not
of income during the laid up period.
Only 20 days, my lord, awarded. 2022.
1722. 1722 million.
That is 15,500.
Considered.
That is considered. That is, but the loss of earning for the laid up period, my lord, only.
At least 5 months, Mr.
But in my lord, internal page 11 may kindly be seen, my lord.
Yes.
PW2, petitioner has sustained deglowing injury to right foot. When the amputation has done, it is not forthcoming the judgment.
Crushed deglowing injury of right foot. Physical.
The doctors have done para 3.
As far as loss of income during the laid up period is concerned.
Please, my lord.
No, let's go step by step. Then we'll go to that.
Please, my lord. But before that, my lord, amputation of foot is concerned. That's what, my lord, I
My
noticed to my
lord,
lordship. Is not forthcoming in that, that's why.
para 4 of the doctor's evidence, amputation up to mid-foot. My lord, here the leg has been amputated, the feet has been amputated. My lord, photos also produced along with other the documents.
According to the doctor, what is the disability?
25%,
Court had taken?
8%.
According to you, how much to be taken, Mr. Shastri?
20, my lord, actually is a driver come owner. My lord, as per the principle of Rajkumar case, my lord, some 25% seems to be lower side. It is left to the court, my lord, left to the court. But on record, doctor said 25% whole body.
Doctor says 25% is.
My lord, he is not a white collar job holder. My lord. That is why
Yes, we'll hear Mr. Pradeep. Yes.
Doctor says 25% to the whole body.
No, it is a crushed injury to the foot.
Foot, yes, ma'am.
And so what you have the TCR is there? Give the TCR. We'll see from the
photo of my lord, kindly see the photos.
Because he's the driver, it would have an impact if it is a foot is he has a crush injury and the toes are removed. Something is saying.
Please, my lord, PW2. The doctor who is an expert who has given evidence, who has deposited 25% to the whole body.
Now, whether in like any other case, we have to take it as 1/3. Considering
No, I'm saying that the entire 25% may consider, my lord, not 1/3.
Yes.
In this particular case is concerned.
So 12 into what is the multiplier? 17.
29.
17 into 25.
And like a future prospect is to be added because over and about 20% I am entitled. Below that I am not entitled. I am not arguing also.
So far as amputation is concerned, it has to be considered. So far amputation is concerned, future prospect has to be considered.
It's 40.
40%.
It comes to 6,200. Is 21,700.
11 lakhs.
So into 12 into 17 into 25 divided by 100. It comes to 11 lakhs.
6,700.
0670. Then
Yes,
what
I'm
about loss
satisfied.
of amenities?
I'm satisfied. I'm satisfied.
What loss of amenities?
Loss of amenities 70,000 as awarded.
Or where is it?
No, not awarded anything. 70,000 is the food and
Food and
nourishment.
nourishment charges.
70,
that is coupled with
70.
amenities.
No.
So amenities in these kind of cases, how much? We will deduct it there.
Please, madam. Then, my lord, 50,000 another.
How many days he was in hospital?
20 days.
23 days total. 22 days plus 1 day.
Incidental expenses 23,000 and loss of amenities 60,000.
Please.
Legal expenses 10. But actually, Mr. Shastri doesn't want all this. With loss of future income, he is satisfied.
Normally, your lordship may notice I am not arguing too much on the quantification because money will be deposited before the trial court and I am only to brought it to the notice of the court. Only it is my duty.
From hereafter, I have decided that whoever argues the case on point immediately, I will take up their cases in priority.
So my 24, 25 cases will be disposed of very shortly.
That's what it's all about you. How you will do. I think it's coming to 16 lakhs, 88,744.
744.
Please come. Agreed with award passed in emergency number 4110 of 2022, dated 2nd December 2023, the claimant is before this court seeking enhancement of the compensation. Paragraph number 22. The tribunal has granted the compensation as per the table given below. Learned counsel appearing for the claimant submits that the claimant is agreed only on the loss of future income and loss of amenities. It is submitted that even it is submitted and loss of income during the later period.
And parent suffering also one helped
and parent suffering. It is submitted that the claimant had sustained, as per the evidence of the doctor, the claimant has sustained crushed, deglowing injury of right foot and has sustained permanent physical disability of 25% to the whole body. But the court had taken it at 8% to the limb.
Whole body.
8% to the whole body. 8% to the whole body. It is submitted that even at the head of loss of amenities, no amount is granted. And on all the counts, that needs to be enhanced. Learned counsel appearing for the respondent insurance company submits that the compensation that is awarded by the tribunal is just and reasonable. He submits that in the incidental expenses, the court has also added the amenities and no enhancement is called for. Next part. Having heard so and so, so and so. As far as pain and suffering is concerned, court has granted 1,20,000 and no interference is called for. Incidental expenses, he was there in the hospital for 23 days. Hence, this court is granting 23,000. Medical bills, as it is, 2,21,544. Coming to the loss of income during the later period, considering the injury for 5 months, 15,500 into 5, 77,500. Coming to the loss of future income, as rightly argued by the learned counsel for the petitioner, as he has a crush injury and he is a driver by occupation, this court is inclined to take the 25% of the limb disability as whole body disability, and also 40% for future prospects. 15,500, 40,000 future prospects would come to 6,200. That is 21,700 into 12 into 17 into 25 by 100 is 11,6,700. Loss of amenities. This court is granting an amount of rupees 60,000. In the light of the law laid down in Mekala, 10,000. Altogether, the claimant is entitled for an amount of rupees 16,88,744. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 7,05,144 to 16,88,744. Yes. Huh? Huh? And that they will do in all. Yes.
Number 9.
I'm appellate in this case, my lord.
Injury enhancement. It's a case of injury enhancement.
Where is the table?
Loss of earning has not been considered, my lord. Table is page.
Where is the table?
Table para 22 minutes. Page number para 26, page 22.
Page 22, my lord. Facial injury, due to facial injury, the tribunal has not considered any injury at all. Future income.
My lord, the facial fractures, it will not affect to the avocation of the injured. On that basis, my lord, other rates, my lordship, the MSC has interfered.
So, which year is the accident?
22, my lordship. 23/4/2022. Here, my lord, loss of future earnings not granted, my lord. That's what, my lord, other rates tribunal has granted generously.
Amenity still, what is the disability to the, as per the doctor?
34%.
34%.
So amenity.
Doctor has assessed, my lord. And surgery has been done.
Another 50,000 may be ordered. Facial fractures, my lord, that's all.
My lord,
Loss of
surgery has been performed, my lord. Doctors has assessed.
Nasal bone fracture and nasal bone fracture, my lord, and facial fractures.
Page 13, my lord.
Surgery has been conducted to the facial fracture injuries. That, my lord, future medical expenses 20,000 awarded.
No. What is the doctor's evidence with regard to the nasal bone?
Total, my lord, the doctor assessed facial fracture 34%. That is not affect to the avocation of the injured, my lord. That is the conclusion by the MSCD. On that basis, my lord.
If it is disfiguration, it's a different aspect. It's a different aspect. No, because of the facial injuries or any of the fractures, now the jawbone and other things are.
No, my lord, that is not.
What are the injuries? Let's say. Let's see that.
Fracture of, please, para 19, my lords.
Paragraph 19. I think internal page 12.
Please.
Abraded wounds over lips and scalp.
Operation.
Left occipital region. Injuries at the angle of mandible.
Mandible fracture.
And nasal septum.
Nasal fracture and mandible fracture. Mandible fracture. Nasal fracture.
It will have impact.
Please, my lord, but evocation is concerned, my lord.
What avocation?
The facial fracture, that is the judgment is there, that the basing on that.
Facial fractures, some like, because of that it disfigured. Now a person is not able to eat because of all these fractures. Won't it have an impact on his life? And unless and until a person is physically fit, it will definitely have an impact on his future earning.
But
Just it is disfigurement, we can understand. No, mandible fracture definitely will have impact on his chewing and other aspects, and nasal one. Now, because of that injury, if that he keeps on getting any infections.
Judgment of the apex court has been referred in para 18.
Para 18. Yeah, let's see.
The Honorable Apex Court in Rajkumar versus Ajay Kumar reported
Who
in.
treated the injured claimant for there's extent to the permanent disability can give evidence only in regard to the extent of the loss of earning capacity is something that will have to be assessed by the tribunal with reference to the evidence set in entirety. Oh, what I'm trying to say is, no, facial injury, only the impact of it is disfigurement. It will not have any impact on your.
Then my lordship has to interfere all the aids, my lord, because the tribunal has not awarded loss of future earnings. That basis, my lord, the loss of laid up period 90,000. Loss of amenities.
We will do that exercise. Let's see how it will, whether it will make any difference. So, loss of income during the laid up period. It is 15,500.
Yes,
15,500. 500 into 4. It comes to 62,000. Then loss of amenities. How much the court has granted?
50,000.
That will continue. Then how many incidental expenses?
Incidental expenses, 25,000.
No, how many days he was in hospital?
10 days, madam.
10 days. So we'll grant 10,000. Then medical expenses as it is.
One lakh 80,500.
500. Future medical expenses according to the doctor, how much?
Doctor, my lord, 20,000 only, my lord.
He said 20,000.
No, my lord, sorry. 80,000 doctor suggested, my lord.
So it's a more of a cosmetic surgeries.
That is not.
So court has granted 20, will grant 40. No loss of future income.
I mean, pain and suffering.
Pain and suffering 1 lakh it is granted. So we'll grant how many? 3, I think.
60,000.
60,000 will grant. So loss of future income. The disability according to the doctor is
34%. Facial disability.
So it can't be 1/3.
10%. 10% lordship may consider. If my lord, if head injury all my lord, then my lordship not bifurcated. But facial fracture is concerned in the Honorable Court has also several judgments are there. In the facial fractures, loss of future earnings not awarded in that judgment. My lordship could have considered 10%.
Then 15,500 into 12. What is the multiplier?
Multiplier. You just. $38 years, my lordship. 38 years.
15.
15 multiple.
15 into 11 by 100. It's coming to 3,06,900. Legal expenses
Two lakh 79,000 future earnings,
No, for me, it's coming to, I took 11%.
11%. Yes, ma'am. 10%, that's different.
It's coming to 7,19,400 from 4,65,500. Please count. Agreed with the award passed in MVC number 688 of 2022 dated 21st October 2023. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below. Land counsel appearing for the claimant submits that according to the doctor, when the claimant has sustained 34% disability to the face, the court ought to have considered the future loss of income. And even on the other heads also, the amount of compensation that is awarded by the court is not just unreasonable. Next paragraph. When counsel appearing for the insurance company submits that the court has not granted any amount under the head of future loss of income because the injuries to the face would not have an impact on the income, and the court had rightly considered and granted the compensation. It is submitted that because the court has not considered the future loss of income on all other counts, the court had granted exorbitant amounts. It's submitted that no interference is called for. Next, having heard the counsels on either side, peruse the material on record. The claimant had sustained the abraded wounds over lips and scalp within bracket left occipital region. B. Injuries at angle of mandible and nasal septum. The doctor has opined that the claimant was evaluated and underwent CT scan for facial bones and diagnosed with a fracture of bilateral nasal bone, left angle and body of mandible communities, fracture of left parietal and outer wall of the frontal bone. And the appellant has underwent surgery for orifice with plate and screw for fracture of left angle and body of mandible, suturing of left, scalp laceration by plastic surgeon, nasal bone fracture reduction, and then discharged on 4/5/2022. The tribunal has not considered the future loss of earning. They are considering the judgment of the apex court in Rajkumar versus Ajay Kumar and Annar, reported in 2011, 1 SCC 343, where the Honorable Apex Court has observed that the doctor who treated an injured claimant or who examined him subsequently to assess the extent of his permanent disability can give evidence only in regard to the extent of permanent disability. The loss of earning capacity, there is something that will have to be assessed by the tribunal with reference to the evidence in entirety. Considering that the court felt the petition, the appellant, the claimant is not entitled for any compensation under this head. Next paragraph. Their contentions are recorded. This court has perused the injuries that are sustained by the claimant. There is a injury to the nasal bone. There is an injury to the mandible, which would have an impact on the day-to-day life, which will consequentially have an impact on the person's earning capacity. In those circumstances, this court is inclined to take the disability, 1/3 of what is given, 34 at 11%. So 15,500 into 12 into 15 into 11 by 100 is 3,06,900. Under the head of pain and suffering, this court is granting 60,000. Coming to the loss of income during the later period, 15,500 plus into 4 will be 62,000. 62,000. Loss of amenities 50,000. As he was in hospital for 10 days, incidental expenses 10,000. medical expenses has nothing to interfere. Future medical expenses, considering the operation that he has to further have, this court is granting 40,000. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 7,19,400. Accordingly, appeal of the claimant is partly allowed by enhancing the compensation for 4,65,500 to 7,19,400. The 6% interest. Yes, next. It is condoned on condition.
139 days.
139, he will not be entitled for interest. Look at the order.
Cell number
Yes.
10, Lingraj HS.
Cell number 10, my lord, it's inpatient ward case. It's pending. Post 11, the matter has been posted for after 3 weeks or 4 weeks. my lord.
This matter.
R2 and R3.
Huh?
For R2 and R3.
List this matter after 4 weeks at the request of.
Copy not served, madam. Please direct.
The appellant will serve the copy on the council. List it after 4 weeks. Yes, 11.
Cell number 11, David Satish Chandra.
List this matter on 18th of November. Yes, 12.
Cell number 12. Cell number 12.
In this case, the claim petition is dismissed on the ground that investigation officer is not examined. The hit and run case, my lord. FIR is registered stating that hit by car. After investigation, police have filed a charge sheet against the offending car driver. Tribunal has held that investigation officer is not examined.
Why he should be examined? Yes.
The case of hit and run, my lord. The
Charge sheet is filed.
Charge sheet is filed.
Please, my lord, but
Anyway, you will not come to the court and tell something contrary to the charge sheet.
please, my lord, but that the other aspect, my lord, is that's a case of hit and run. How the vehicle has been traced out, that has not forthcoming. That is what, my lord, MSCT has elaborately discussed and laying upon the
And what is the owner of the
judgment of
vehicle
this honorable
saying?
court.
Owner of the vehicle is saying.
It was placed
Expert, I mean, it does not appear.
In a similar case, apex court held that the charge sheet
Take
is,
that.
sir. Next, involvement with the vehicle, claimant by the claimant.
Which paragraph?
In this case, para 6 to 17, 6, 17, 21.
The respondent and insurance companies also. Then come to paragraph number 17.
17. The very
Let's read.
fact,
Please read.
the very fact that the case was registered against the unknown vehicle initially would indicate that the offending vehicle was not identified. However, since on FIR is not expected to be encyclopedia, see Superintendent of Police also, and is only for the purpose of putting into motion criminal law such that through and full-fledged investigation by the police ensures it is the duty of the investigating agency to find out the identity of the culprit, which in the present case would be offending car and the driver, and take the action in accordance with law. Thus, the mere fact that initially the FIR records and vehicle as unknown would not be fatal for the prosecution. Claimants to later come with the specific identity of the vehicle public driver, with the obvious caveat that the connections of the accident with the said vehicle has to be based on the cogent and eligible evidence. In the present case, the factor in favor of the insurance company is that the conduct of the so-called eyewitnesses, PW, who was the consumer at a pawn shop, gives his statement to the police about 2.5 months after later the accident, disclosing that the registration number of the offending vehicle. This raises serious doubts on the authenticity thereof, as states that he had noted it on the piece of paper that when he again visited the spot after 15 days, he came to know that the injured had passed away, but even after lapse of the said 15 days, he neither informed the pawn shop owner nor produced handed over the chit of papers to the police on which he claims the registration number of the offending vehicle was noted. Next is para 21. The court is left with no option but to presume that the owner of the alleged offending vehicle, which was the cause of the accident, had no defense to offer before any of the three forums, including this court. Moreover, it transpires for the records that
This is all about facts of a case.
yes,
It doesn't lay down any ratio. The court says in the facts and circumstances where there is evidence on record that a particular vehicle is involved and there is no contra evidence that with regard to the non-involvement of the vehicle, court said it is. But what is the finding of the tribunal, we'll see.
in the
Para 14 on what's going to be
para 15.
The 14 starts from 14.
It must be medical evidence.
Please, madam, they have not produced.
Medical evidence hit by car. It has come in the
No,
medical records.
the MLC is there.
MLC is there.
Let's see that.
In discharge summary also,
Exhibit, sir.
Please come to the exhibits.
exhibit P.
What are the exhibits?
Exhibit P 8.
That is
So
discharge
when is
summary,
the
that's not
accident?
MLC.
No, when is the accident?
Accident on 24
24 to 2023.
20?
24 to 2023.
on the same day was taken.
2020.
2023.
2023.
Accident is 24 to 2023.
20.
When was the FIR?
25 to
On the
2023.
next day,
24 to 2023, time of accident?
12 noon. 12 noon.
12.
Noon.
12. After
25 to 2023, FIR.
FIR.
It says unknown vehicle.
Unknown.
unknown.
Then when the vehicle was shown,
At 14th day, it was seized. and
amended complaint.
No. No further complaint, no further.
So on 25 to, when was the complaint, when is the FIR when, naming the
FIR.
vehicle?
25 to 2023 only.
No, that is the initial FIR.
Yes.
Later, the vehicle is shown. When
Vehicle
It has not shown
on-
that straight away in the
on
charge sheet is
14th
coming.
14th day, that's the 9/3/2023. Vehicle was seized and inspected by the,
in the charge sheet, it must have been stated. Take
Yes.
the charge sheet. The charge sheet is in Kannada.
P7.
Yes.
Give it to him. Exhibit please.
Before that, my lord, MLC has not produced. My lord, no friend saying discharge summary. If my lord, it is a road traffic accident, my lord, the hospital authorities should have sent to the concerned police station with regard to the alleged accident. That is not produced before this court.
Which is the hospital? Is it a government hospital?
Rajarajeshwari Hospital.
Look at it, look at the charge sheet. How did they, how that the vehicle is, shown?
The problem is that, my lord, they have produced not a full charge sheet, my lord. Only that portion of the charge sheet they will produce. Witness statements, how it is elicited the vehicle, everything is not forthcoming in this charge sheet, my lord. Because they were following
So
only
something must have
the charge
happened to
sheet.
the charge sheet.
Please, my lord, charge sheet is,
No, what has happened?
the full charge sheet, my lordship knows, full charge sheet, 161 statements and all will comes. In the MEC cases, no one produces full charge sheet, my lord. The part of the charge sheet they will produce. In only, my lord, the brief facts only in para number 17. That's what, my lord, is coming in charge sheet. Except that, my lord, nothing will come.
In this case, I have filed the application for the remand in the case to examine the.
My lord, no friend may establish the case, no issues.
Please come. The present appeal is filed. Agreed with the dismissal of MVC number 2912 of 2023 dated 1st June 2024. The claim petition is filed seeking compensation under section 166 of the Motor Vehicles Act. It's a case of the claimant that on 24/2/2023 at about 12 noon, while the claimant was proceeding in his car in his Honda Activa on the left side of the Mysore-Bangalore highway. At the time, the driver of the car came at high speed in a rash and negligent manner and dashed against But we have to pass an order on at high speed in a rash and negligent manner and dashed against his vehicle from behind. Result of which he fell down along with his motorcycle and sustained grievous injuries. Immediately was taken to the hospital. The insurance company has denied the involvement of the vehicle as it's a case of hit and run. And though the charge sheet is filed against another vehicle, how, when, and all these things have come into light, nothing the charge sheet do not disclose. The tribunal, by order, impugned and dismissed the claim petition. And while dismissing the claim petition, the tribunal has observed that
Para 21,
I see.
page 15.
The tribunal generally places reliance on the FIR, mortgage and charge sheet in all cases when there is no serious dispute by the insurance company. Though the court is not examining the correctness of the charge sheet, but the court has to take judicial note of the conduct of the investigating officers who are investigating the road traffic accident cases. The charge sheet submitted cannot be accepted as a gospel truth in all cases. In the recent years, it has become rampant where investigating officers, in connivance with the claimants and also the owner of the vehicles involved in the accident, are distorting the facts to suit their purpose and accordingly to enable them to claim compensation. In the first instant, the alleged vehicle number is not mentioned. The petitioner has not produced a rough sketch notice under section 133 of the IMB Act and reply given to the said notice. The petitioner has not examined the investigating officer and not elicited the mode and methodology adopted by him in conducting the case and filing charge sheet against alleged offending of vehicle. There is no item of material placed on record to let the court to know how the investigating officer has traced the alleged offending vehicle as a vehicle involved in the accident. Though PW3 has been examined to prove the case of the petitioner, but as I've observed, Supra is not at all an eyewitness to the accident. He is planted as an eyewitness to the accident and hence leaving a part of providing the rash and negligent act on the part of the driver of alleged offending vehicle. The petitioner has failed to prove the very involvement of the offending vehicle and dismiss the petition. When counsel appearing for the petitioner submits that appellant submits that if an opportunity is given and the matter order impugned is set aside and the matter is remanded, he would get an opportunity to adduce further evidence. And hence the matter may be remanded. When counsel appearing for the insurance company submits that the petitioner has not filed all the documents before the court, the charge sheet, the complete charge sheet is not filed, wherefrom the court would be able to appreciate the statement of the witnesses under section 1631 of the CRPC. It is submitted that the court under these suspicious circumstances has rightly dismissed the application and there are no grounds to
MLC also not produced.
MLC
Medical
was
legal.
not produced. MLC was not produced and court had rightly dismissed the application. It's having heard so and so so and so. There is no dispute of the fact that this is a case of hit and run. Initially, when the accident had taken place on 24/2/2023, FIR was registered on 25/2/2023. On that day, which is the vehicle involved in the accident is not mentioned. Thereafter, they filed a charge sheet against the vehicle. As rightly contended by the land counsel, the respondent, how the police have found this vehicle as being involved in the vehicle is not known to this court. Is not known, and nothing is forthcoming in the evidence on record. And the court had rightly dismissed the application. However, considering the fact that this is beneficial legislation, considering the plight of the claimant, and to give a reasonable opportunity to both the parties, this court deems it appropriate to set aside the award date to so and so, and remand the matter to the trial court for fresh consideration. Without further notice from the court, the party shall appear before the court by 24th November. Is As in the view of remand of the matter, IS officer so is responsible.
LCR kindly.
Else, everything, order will contain all that.
Cell number 13.
Yes. Yes.
The remove of 50% negligence. The vehicle involved, tractor and trailer, at about
50% contributory negligence is.
contributory negligence.
That is one aspect.
That is one aspect.
You are seeking enhancement.
Enhancement.
So first we will see enhancement.
Enhancement.
Contributory negligence.
Enhancement is in the absence of, is the driver working as a driver and agriculturalist.
Come to the, oh, it's a case of death. Now, which year is the accident?
That is 18. That is 18/9/2018.
Then it is 12,500. How much the court had taken?
Court, that is 12,500 taken, Your Lordship.
Then nothing on loss of dependency.
Loss of- Only for negligence.
Then no, you said you were seeking enhancement.
Then, and other rates is lower side, Your Lordship.
That we will see.
Yes.
Loss of dependency is 17 lakh, 85,000. How many are the claimants?
I mean, only two claimants, Your Lordship, unmarried daughter,
Also
that is
consortium.
wife.
44 into 2, 88. 36,000 funeral expenses.
In this case, Your Lordship, the vehicle involved in
So
the,
please come to the finding. We will read it. Where is the finding? Which paragraph?
that is para number 20, page number 20, para number 15,
Please read.
internal page number, the trial court judgment, para number 15.
Please read.
Further, PW had produced FIR along with the information of Exhibit P1, P2 Major, P3 sketch, Exhibit P4 Caesar Major, Exhibit P7 MUE report, and Exhibit 16 final report, and perusal of those documents in that Exhibit P1 disclosed that Shumagga East Traffic Police have registered the case under crime number 119/2018 on the basis of the first information.
For the rider or a pillion rider?
Rider.
So
Pillion rider is the eyewitness.
police have filed the charge sheet against you and
And,
the driver of the offending.
Offending,
Have you filed any protest petition?
no.
Then
Then Your Lordship, it is under section 122 of the Motor Vehicles Act, the parking the vehicle without signal and without indicator.
further we will read.
Yes, Your Lordship. Investigation afterwards, Shumagga for East Traffic Police have conducted the investigation and filed the final report against the driver of the tractor and trailer and rider of the motor vehicle bearing registration number so and so for an offence punishable under section 279, 338 and 304A IPC, and examined of PW 1 to 4, 7 and 16 oral evidence PW 1 and PW 2. It reveals that
The date of time of accident.
6:30 PM. It is NH 69 from Mangalore to Sollapura. The accident took place on Shumagga city near about 5 kilometers. It reveals that firstly the accident was occurred in front of Veerbhadrappa's house, Purle village. It means to say that so the accident was occurred within the village of Exhibit P.
Date of accident is?
Swami?
Date of accident is?
18/9/2018 at about 6:30 PM. Sketch disclosed that so the tractor was parked in front of Veerbhadrappa's house, little bit away in the middle of the road. It means to say that so tractor was parked on the middle of the road. It is admitted as per the police records the tractor and trailer were parked in prohibited roadside. At the time, the rider of the motorcycle came from Vale Belavanalli toward Shumagga by riding in rash and negligent.
1 minute. What do you say?
Lord, it's the tribunal order is justificable. After investigation, the police have filed the charge sheet. It is not the case that the tractor and trailer dashed to the motorcycle. It is the prosecution discloses that the deceased himself dashed behind the tractor.
Because it is not visible to him.
My lord,
So parked it on the middle of the road and
little bit the observation is little bit not on the exact middle of the road, but the side of the road. My lord, even assuming it is the duty of the rider to see the vehicles or any pedestrian and have to go proceed.
Your duty to, when it is on the road, there should be the parking lights on.
Yes. So there is justification
No,
in.
what I'm saying is, we will reduce the contributory negligence, not 50%.
Yes.
How much?
My lord, he was rider. He is not a pillion rider. He was so rash and negligent that he could not control his vehicle and he dashed behind the trailer.
Firstly, your lordship 122.
All that provisions are not required, Mr.
Act.
Counsel.
Act.
The deceased also should be cautious, madam. The deceased should also be cautious.
Correct. That's why we are fixing contributory negligence on him, not 50%. Comes to 19,19,000.
My lord, one more submission I would like to.
1 minute. 1 minute.
The deceased was bachelor, madam. Bachelor.
You have not filed any appeal.
No,
We will
not
go into
filed.
that. With regard to
We
the
are
quantum,
satisfied
I'm
with
not-
50%.
But I'm not only on the other heads,
Neglig-
consortium and all, I have increased. Only,
one-
only
one-
that
one-
is 40,000 rupees is enhanced.
Madam, one submission, my lord. in this.
Yes.
The tractor insured by the respondent number 4, Chola Insurance Company. The trailer was not having insurance. Trailer was not having.
All these grounds you can't afford to argue before the court without filing any appeal. I fixed the contributory negligence at 30% on the claimant, on the deceased. Please come.
25%.
Agreed with the word passed in. It is not even the night time at 6:30.
Yes, sir. 8:30.
6:30 you said.
That is 8:30.
Just now you said 6:30 PM.
As per the judgment, your lordship, 8:30 PM. 8:30 PM.
Agreed with the word passed in MSC number 635 of 2020 dated 15th June 2023. Whereby the contributory negligence is fixed at 50% on the claimant, 50% on the driver of the offending vehicle. The claimant is before this court and also seeking enhancement. The tribunal has granted the compensation as per the table given below at page 20. The tribunal has fixed the contributory negligence at 50% on the claimant as the FIR was registered against the driver of the vehicle as well as rider of the vehicle as well as the driver of the offending vehicle. The court has observed that on examination of exhibit P1 to 4, 7 and 16 and oral evidence of PW1 and PW2, it reveals that firstly the accident occurred in front of one Veerabhadrappa's house. It means to say that this accident was occurred within the village, and exhibit P3 sketch discloses that the tractor was parked in front of Veerabhadrappa's house, little bit away in the middle of the road. It means to say that the tractor was parked on the middle of the road. It is admitted as per the police records, the tractor trailer were parked in prohibited roadside. At the time, the rider of the motor vehicle came from was going towards the Shivamogga side by riding in rash and negligent from behind and hit the parked trailer. That's the court come to the conclusion that the initial negligence is on the part of the driver of the tractor trailer, and the next the negligence is on the part of the claimant, on the part of the deceased, and accordingly contributory negligence was apportioned at 50% on the claimant and 50% on the driver of the, 50% on the deceased and 50% on the driver of the offending vehicle. When counsel appearing for the appellant submits that the tribunal has erroneously fixed the contributory negligence at 50%, it is submitted that the accident has happened solely because of the negligence on the part of the driver of the offending vehicle, of the tractor who has parked the tractor on the middle of the road without the parking lights on. As the accident had taken place at 8:30, as the claimant had failed to see the same, the accident had taken place. So there is no contributory negligence on the part of the claimant. Further, it is submitted that when it comes to the compensation under the conventional heads, the amount that is awarded by the tribunal is not just and reasonable. Next para. When counsel appearing for the respondent insurance company submits that the charge sheet is filed against both the driver, both the deceased as well as the owner of the tractor. It is submitted that everywhere wherever I said driver, make it owner of the tractor. Owner of the tractor. It is submitted that when it is in the village and when there is his observation of the court that he was going in a rash and negligent manner, had he been taken precautions, this accident could have been avoided, as there is clear negligence on the part of both the deceased and the owner of the vehicle in parking the vehicle. Court had rightly fixed the 50% contributory negligence, and the compensation that is awarded by the tribunal is also just and reasonable, and no interference is called for. Next, having heard the counsels on either side, there is a material non-record. First, coming to the aspect of compensation under the head of loss of dependency, court has rightly granted the compensation. Coming to the loss of consortium, two claimants, 44 into 2, 88,000, funeral expenses 36,000, and the legal expenses 10,000. Altogether, the claimant is entitled for 19,19,000. Then coming to the contributory negligence, the accident had taken place at 8:30 p.m. It has taken, and it is in the village. Admittedly, the vehicle, the tractor is parked. Part of the tractor is parked on the road, tractor trailer, and no parking lights were on. So there is a clear negligence on the part of the owner of the vehicle in parking the vehicle almost in the middle of the road. Then coming to the deceased, had he been careful, this accident could have been avoided because this happened in the village, not that it is on the highway. In those circumstances, this court is of the view that the contributory negligence can be apportioned at 70% on the owner of the tractor and 30% on the deceased. The compensation now that is awarded by this court is 19,19,000. Hence, the insurance company is liable to pay 13,43,300. Accordingly, the appeal of the claimant is partly allowed. Yes.
314.
Huh?
314.
On condition. 314, no interest.
Bill number 14.
No interest.
No interest.
14.
Second respondent.
Harish NR.
DL issue, please, my lord. Accident took place after the amendment.
Third party.
There is no DL as.
The deceased is a third party, my lord. Claimants are the legal representative.
No, it is not about third party or first party. Issue is about what is the after the amendment. What is the consequences of not having a DL?
One judgment I will in the 29.
Come up with the judgment. This is matter on 11th, not 11th, on 12th of November.
Please, relaying Singh case, the claimant should not.
Get it. We'll see once you're with the case 15.
15. C.R. Ravi Shankar.
Needs time. This is a matter on 19th of November.
Bill number 16.
The claimant's appeal. This case of death, my lord.
P. Pradeep.
Case of death.
Yes.
Deceased was bachelor in age 22 years, has become graduate. tribunal has taken on 14,500 rupees as income, notional income.
What is future prospects? What is this?
Separate, it's bifurcated, my lord.
Oh, let's see. What is the age?
22 years, my lord.
22 years.
22 years. Bachelor.
Bachelor.
He was a BCom graduate.
Which year is accident?
26/8/2020.
26/8/2020.
He was a
14,000.
he had just finished graduation, BCom graduation. So tribunal taken only notional income 14,500 rupees.
PW1 given evidence stating that my lord, his son was working in TVS showroom. But they have not placed any material to show that he was working in a TVS showroom.
But even otherwise, he was a graduate. That is, that's exhibit P14, and they produce the mass cards and.
No, when he's working, why don't you place the evidence? I will remand the matter, do it, because when he's already working.
He had just signed, because a graduate, at least 20,000 may be taken since he was a BCom just finished his graduation.
Please come.
And accident occurred in the, let's say one second aspect is that accident occurred 25/2020, suffered severe head injuries, and he died on 7/10/2021 after 5 months. That loss of earnings when later was not given, and no compensation towards attendance charges during that period. It was continuous under treatment in the hospital.
You know, one thing, if you say it has to be taken at 20,000, I have to remand the matter. If not, if you say some other amount as thing, I will consider all this.
No, because the graduate was that's all. Because I cannot produce any better this one.
Because you're working somewhere before that.
Was not working, but not producing document to show that at least for a graduate.
Agreed with the award passed in MVC number 3977 of 2020.
And died after 5 months.
June 2023, whereby the tribunal has granted compensation of 38,75,286. The claimant is before the claimants are before this court seeking enhancement of the compensation. It is submitted that the court has taken the notional income at 14,500. Is a BCom graduate. The court ought to have taken 20,000. It is submitted that after the accident, he was hospitalized. He has spent amounts to the court has not granted any amount towards the attendance charges, and also no loss of income during the later period.
20,000 awarded conveyance and
Is sufficient. Is not granted. It is submitted that on all counts the compensation needs to be enhanced. Land counsel appearing for the insurance company submits that as per the evidence of PW1, the claimant, the deceased, was working in a
TVS
showroom, and they have not placed any evidence on record to show what is the income he is getting. Next para, having heard so and so, there is a material on record. When it is a case of the claimants himself that the son is working in a TVS showroom, they ought to have placed evidence on record. The submission of the legal counsel that because he has did BCom, that the court has to take 20,000 as income. This court is not able to appreciate the submission. In these facts and circumstances, this court deems it appropriate to set aside this order and remand the matter to the trial court for fresh consideration. The petitioner is at liberty the appellant is at liberty to raise all contentions. All contentions are left open. Yes.
Cell number 17.
Without further notice, the party shall appear before the tribunal on 26th of November.
Cell number
Yes.
17, Ravish, Vinny.
Company appeal on quantum, please.
Where is he? Counsel for the petitioner is present. No representation on behalf of the respondent. This matter on 13th of November.
Please.
Cell number 18.
Claimant's appeal, my lord, seeking enhancement of compensation and as well as my lord, contributory negligence fixed on the deceased, my lord, 50%.
Deceased.
Please, my lord. Kindly see my para number 12.
First of all, come to the enhancement, then we'll go to the contributory negligence.
My lord, the deceased is a profession by driver, my lordship. I have produced the my lord DL extract. Court has taken my lord 15,000 income.
Which year is the accident?
2021, my lordship.
15,000.
Please.
How much to be taken?
My lord is a driver. At least my lord 20,000. I have produced the DL.
Driver, he only himself dashed the ongoing lorry,
That is,
That's
not
it.
having the
No,
experience.
we are not on contributory negligence. We are on the income.
That's what I am telling. He was not having the experience in driving. He dashed the ongoing lorry.
Basically,
So
what you say
15,000 is the
that
just and proper, my lord. Maybe it's the driver.
field labor, what is that we have to take?
ECA, my lord. Earlier, my lord, before that 2021, the income is 8,000. That has been increased to 15,000. So far as the driver is concerned, skilled driver is concerned.
15,000 as per the
per month.
notification.
Yes,
ma'am.
15,000 has taken, but he's not a skilled driver.
The income is more compared to, I mean, from this chart than the notification of the government. So 15 is taken.
Please.
Future prospects, everything is
Added,
considered.
added.
So let's see.
Other rates,
Yeah, we'll see.
other rates only 10,000 has been awarded.
Let's see. Where is the table?
The table, my lord, is my lord, can listen. Is number.
Page number 23 of the judgment. Only funeral expenses 10,000 given.
So, loss of 50% towards, loss of dependency, 22,68,000, as it is will take.
Yes,
And what about, how many are the?
Father and mother.
So,
Please.
consortium, loss of consortium, 44 into 2, 88. Funeral expenses, 36,000. Legal expenses, 10,000.
Funeral expenses 10,000 awarded. Another.
This is a fresh calculation. It comes to 24,02. Now, please come to that part of the order where the contributory.
Para number 12, my lordship. Page number, internal page number 10, my lordship. Judgment.
Now it is fixed at 50%.
50%, my lord.
Yes, my
And
lord.
page,
May I read?
paragraph number?
Paragraph
12 and 13.
12 and 13, my lordship.
Please read.
12. On perusal of the case papers on record, such as Exhibit P, Exhibit P1 FIR, Exhibit P2 complaint, P3 charge sheet, P4 merger, Exhibit P7 IMA report, it shows that the deceased being the driver of a lorry bearing number so and so. And when he was proceeding near Kaidigala village, Chitradurga, at that time of driver of a container lorry number so and so, all of a sudden stopped offending lorry without giving any signal, any caution to the deceased. Was behind, he could not control the vehicle and he had dashed the said container lorry and they caused the accident. It shows that the offending vehicle was moving in front of a lorry of the deceased and the driver of the offending lorry applied brakes suddenly and stopped the lorry and he deceased could not control his lorry and hit the offending lorry on its backside.
Now,
Please.
In support of your case,
Please.
that because he has abruptly stopped the vehicle, this accident has happened.
To avoid the speed breakers.
So, what is the evidence?
My lord, there is, my lord, in this case, no evidence.
Then-
My lord, and also, my lord, he stopped the vehicle without signal, my lord.
Who will tell we can't assume something. You should have, adduced some evidence.
Para number, it is clearly
Charge sheet
mentioned.
by again both the drivers, my lord. At least, my lord, 50% might is very high, yes, my lord.
This is not a case. Unnecessarily, you have caused the accident.
No, my lord, my vehicle is going, my lord, behind the, my lord, offending vehicle lorry, my lord. He suddenly, my lord, stopped the vehicle, my lord, without caution, without signal, my lord. Even there is no indicator, my lord.
Who will tell all this?
My lord, 50% is a very higher side, my lord.
No. This is not a case where the court has to exercise any.
Like at least, my lord, you know the, my lord, in front of the road there is a speed breaker. My lord, he suddenly, my lord, stopped the vehicle.
Now I'll tell you like this.
Please, my lord.
Because you were not maintaining the distance that is required to be. That's why you couldn't stop the vehicle. You should know. You should anticipate that if there is a speed
breakers.
breaker, he will stop so that you should maintain the distance.
Malad, how no, Malad, in front of the road, Malad, there is a speed breaker. The offending vehicle driver, no, Malad, speed breaker.
All
Malad.
those we can't consider, Mr. Counsel.
Malad, at least, Malad, some portion of Malad negligence, Malad, 50%.
No.
Malad, is this only son, Malad, Malad, father and mother are Malad.
Yes, please come. The present appeal is filed. Where there is a scope for exercising discretion, court will definitely do without you even asking it. Agreed with the what?
No, even though Malad, they have also not Malad, produced any documents, but they are taken only defense. But you know, there is no evidence at all, Malad.
That is your defense. You have come to the court under 166. Burden lies on you, not on them. Once you discharge your burden, then they will adduce.
Malad.
Agreed
Regarding
with
Malad,
about past indemnity
regarding
number.
income, Malad, at least Malad is a driver. If I have not produced the Malad DL, certain Malad I am entitled as per the local.
As per the notification for a driver, it is 15,000. Agreed with about past indemnity number 26 of 2023, dated 23rd October 2024, whereby the court had granted compensation of 11,39,000 and fixed the contributory negligence at 50% on the deceased. The claimants are before this court and counsel appearing for the claimants submits the court has failed to grant a just and reasonable compensation. Further, when it comes to the contributory negligence, it is submitted that when the deceased is proceeding by while driving the lorry, the driver of the container lorry all of a sudden stopped the offending vehicle without giving any signal or caution, and deceased was behind. He could not control his vehicle and dashed the said container lorry and caused accident. It shows that the offending vehicle was moving in front of the lorry of the deceased, and the driver of the offending lorry. No, it is his contention, I said, no? So it stopped here. He could not control his vehicle and dashed the said container lorry and caused the accident. And counsel submits that absolutely there is no negligence on the part of the deceased. It is because of the driver of the lorry, container lorry, who was proceeding in front of the deceased, has abruptly stopped the vehicle. It has led to the accident. And they have not adduced any evidence that the claimant is negligent. It is submitted that fixing the 50% contributory negligence on the deceased is not correct. Next, and counsel appearing for the respondent insurance company submits that court has in detail discussed how the accident had happened, and no other evidence is adduced by the claimant in support of his case. Hence, there are no reasons to interfere. Next, having heard the counsels on either side, peruse the material on record. This court has perused the order passed, wherein the court has in detail has recorded how the accident had taken place. The contention that because he has abruptly stopped the vehicle, the accident has happened, and there is no negligence on his part, and the deceased was maintaining a correct distance. No evidence is adduced before the tribunal. And when the claimant has come before the court by filing an application under section 166 of the Motor Vehicles Act, the burden lies on the claimant to prove that there is negligence on the part of the driver of the opposite vehicle, which the claimant has failed to discharge. Hence, this court is not inclined to interfere with the said finding of the tribunal, where the contributory negligence is apportioned at 10%. Then coming to the compensation, the court had taken 15,000, even if he is a driver, even as for the notification that is issued in respect to the drivers, it is 15,000. Hence, as far as the dependency is concerned, this court is not interfering. As far as consortium is concerned, this court is granting 88,000, funeral expenses 36,000, in the light of the law in Mekhala 10,000. Altogether, the compensation comes to 24 lakhs 2,000. As the contributory negligence is fixed at 50%, the insurance company is liable to pay 12 lakh 1,000. Accordingly, the appeal of the claimant is partly allowed.
Number 19, Guitar. 19, Guitar.
The appellant minutes can be taken after 2 weeks.
Why?
We need some.
This is a matter on 19th. Why even matter? All are served. You can argue. 20.
Need some documents.
20.
Cell number 20, D. Vijay Kumar.
Respond.
Where is he?
Not appeared.
This is matter on 20th of November. No
Cell number
representation on
21.
behalf of the appellant.
21. N.R. Rangegowda, D. Vijayakumar.
Not here. No representation on behalf of the insurance company. List this matter on 13th of November.
Serial number 22. N.R. Rangegowda, F.S.
Yes.
Dabali.
What is this case about?
Lord, case of injury.
Where is the table?
Table, my lord, in paragraph 24 of the judgment.
So what are, how many are the injuries?
Injuries, my lord, suffered
Previous injuries?
previous injuries.
How many?
My lord,
Fracture of parietal bone.
parietal bone, my lord, and sustained head injury.
5 days.
Huh?
5 days she was in.
So it's a head injury, we'll grant 50,000 PS. Then medical expenses as it is.
As it is, my lord. Loss of immunities, my lord, only
1 minute. Let me write this. 57,839. Then how many days was in hospital?
5 days.
Huh?
5
5
days.
days, my lord.
Already enough amount is granted.
Please.
Will not interfere with that. Then loss of income during later period. Which year is the accident?
Lord, 2023.
23, what is the income?
My lord, 16,000.
Get the table also, 23, 24, 25. The table, give it.
500.
Huh?
Additional 500.
And every year and another. So
500
it is
per year.
2022, 15,500. Then it is 16,000.
16,000.
16,000.
Please.
It has been taken.
16,000 will grant for 3 months. Into 3. It comes to 48,000.
Please.
Now, then loss of income, future loss of income. What is the disability?
Disability, my lord, considered 10%.
No. What is the evidence of the doctor?
Evidence of the doctor, my lord,
10%.
10% is
He's not the treated doctor, my lord, because of
Then now, what was the income taken by the court?
same. 16,000 has been
16,000 is taken. Then there is no difference in this.
taken. Even there is no
A
question of
loss of income, future income will come to 3,45,600. Then
Then, my lord,
loss of amenities
loss of immunities, my lord, only.
already granted.
But suffered, my lord, fracture of parietal bone.
Another 10,000
Laid up period, my lord, granted.
already granted.
Only 2 months. 2 months.
3,000, 3 months are granted. 5 months you are in hospital. 5 days.
5 days.
So already 48,300 is granted. 48,000 is granted by this court. It's coming to 5,81,439 against 5 lakh.
15,439.
25. There is a seal on this. I'm not able to see. 5,15,000.
5,15,439, my lord.
Please come.
Out of that, 10,000 interim compensation was paid, which has not been deducted. It has not been
It needs to be
deducted.
deducted 10,000. So if you deduct 10,000, it is 5,05,439. No, 5 lakh. No, in this.
My lord, 10,000 already deducted.
Where?
My lord,
I think,
in paragraph
because
25 of the judgment, my lord.
Look at it. It looks 5,25,139 compensation. So in that, 10,000 is deducted. That's why it's coming to 5
Deducted
lakh.
15,000, 5,15,439.
So in this, from this also we have to deduct.
Please.
So 10,000, if you deduct, it comes to 5,71,439. The agreed with the award passed on embassy number 7562/2023, dated 31st January 2025. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. It is submitted that the court under the head of pain and suffering and the loss of income during the later period And for loss of amenities, the amount that is awarded with the tribunal is on the lower side, and it's the same, and the petitioner, the appellant seeks enhancement of the compensation. Land counsel appearing for the respondent, RTC,
She was a student, not,
RTC,
she was student.
you're,
Yes.
you're appearing for the RTC or insurance company?
Yes, ma'am.
Case RTC, land counsel appearing for the-
PMTC, ma'am.
PMTC submits that the tribunal has granted just and reasonable compensation, no enhancement is called for. It's the court under the head of future loss of income and incidental expenses, medical expenses as rightly granted. There are no grounds to interfere. Coming to the pain and suffering, considering the head injury and the other previous fracture, this court is granting 15,000. Coming to the loss of income during the later period, as this accident has happened in the year 2023, taking 16,000 as income for 3 months, 48,500. Coming to the loss of amenities, this court is granting 40,000.
16,000 per month.
What is that?
16,000.
That type. Loss of amenity. Coming to the legal expenses and the light of the law laid on vehicle at 10,000. Altogether, the claimant is entitled for an amount of rupees 5,81,439. As already the insurance company has paid, and the BMTC has paid 10,000 as initial compensation. The same is deducted. The same is deducted, and it comes to 5,71,439. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 5,25,139 to 5,71,439. 5 lakh, I think we have to take the other one from enhancing the compensation from 5 lakh.
15,000.
15,000. 5,15,439 to 5,81,439. Yes.
Cell number 23, NR 100 order for petitioner P. Pradeep.
Yes, Pradeep.
It's case of injury.
Where is the table?
Table, my lord.
Table, my lord.
You have already prepared?
Please.
Take that.
Internal page 23.
Please come. The present appeal is filed. Agreed with the orders passed in MVC number 5428 of 2023, 86 June 2024. The claim petition is filed. Compensation of an amount of
3,44,680, my lord.
No, what is the amount sought for?
25 lakhs.
Seeking
25
compensation of 25 lakhs. The tribunal has granted the compensation as per the table given below at
Internal page
page
23.
number 23F. The land counsel appearing for the claimant submits that, and the head of pain and suffering and loss of income during the later period, and also towards disability and loss of income, future income towards disability.
My lord, one submission, my lord. Is it serial number 21, my lord?
Disability.
Loss of amenities not awarded.
The attendant charges, the amount of compensation that is awarded by the tribunal is not just and reasonable. Where are the amenities in this?
Amenities 20,000 I mentioned in my.
And no amount is granted towards loss of amenities. Land counsel appearing for the respondent insurance company submits the court has granted just and reasonable compensation. No enhancement is called for. Considering the fracture injury that is sustained by the claimant and the head of pain and suffering, this court is granting 40,000. And towards medical expenses, no interference is called for. Coming to the loss of income, as this accident has happened in the year?
In the year, my lord.
23, my lord. Income rightly considered 16,000.
In the year 2023.
23,000.
16,000 for 3 months.
3 months.
3 months, 48,000. Towards the disability, the court had considered the disability at
8%.
8%. As
Doctor
a whole
assess,
body disability.
doctor assess particular limb disability 36%.
36%.
12% to the whole.
13%.
12% to the whole body.
No, you calculated at 13%.
13 multiplier. 12%.
12 this side.
This side.
12%. 16,000 into 12 into 13 into 12 by 100 is 2,99,520. Then towards food and nourishment, he was there in hospital for 14 days, and this court is granting 14,000. Towards Both together towards
That's
the
what I
entire
meant.
incidental expenses, 14,000. Towards amenities, the court has not granted any amount. Considering the disability of the 12%, this court is granting 20,000 towards amenities. In the light of the law laid down in Mekla versus so-and-so towards litigation expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 4,85,520. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,44,680 to 4,85,520. Next matter,
286 days delay.
286
Interest not.
days delay,
Cell number
not
20.
not entitled for interest.
24.
In
Yes.
this case, my lord, only 2/8 my lordship requires for interference.
Take that.
I made a mark and 2/8.
Agreed with award passed in MVC number 7019 of 2022, dated 9th August 2024. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table at paragraph number 17. Learned counsel appearing for the claimant submits that the claimant is aggrieved on the aspect of loss of income during the laid up period and also the loss of amenities. On those two grounds, the claimant is before this court. It is submitted that as per the evidence of the doctor, he has sustained
So
Sustained
52%
Stability
limb
to the
disability,
limb
17% to whole body.
17% to the whole body, but the court had granted only 20,000 towards loss of amenities. Further, it is submitted that
1 month
loss
later
of
period.
income during the later period, court had granted only 1 month and ought to have granted for 3 months.
3 months.
And counsel for the respondent insurance company submits that the court has granted a just and reasonable compensation. Next, having heard the counsels on either side, peruse the material on record. The petitioner is agreed with regard to the loss of income during the later period. Considering the hospitalization, this court is inclined to grant for 3 months, that is 46,500. Then coming to the amenities, loss of amenities, considering the disability of 17%, 17?
17%.
17%.
To the body, whole body, this court is granting 40,000 towards the amenities. Altogether, in the light of the law laid down, 10,000 towards the expenses. Altogether, the claimant is entitled for an amount of 6,51,000. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 5,90,098 to 6,51,000. Accordingly, appeal is partly allowed, enhanced amount 6% any delay. 220 days delay, no interest for the said delay. Yes,
My lord,
if all of you
serial
come
number-
up, this all is over, Mr. Vijay Kumar. Yes.
That's what my lord, I made a synopsis.
Rangagoda is there. I'm ready for disposal. Rangagoda is there, my lord.
I'm not ready. Time is over. Yes.
List number 3 for orders matter sale number 1. Suresh M. Lato, furnishing of PF for R1. Each time I can do granted.
All this list, give some other day. This third list number 3.
17
matters are listed like this. This is the list on some other day. In the look at it with all the list that is given. Accordingly, you post whenever and from now onwards, all these matters on Thursday, Wednesday, and Thursday. Thursday till 1:30. Where is the attender? Ask him to come. You should be here. Ask him to come.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
So,
List number 3.
ನೋಡ್ಕೊಡ್ಬೇಕಲ್ಲ ಗುರುಗುರು ಹಾಕು ಅಂತ ಹೇಳೋರಲ್ಲ ಫೇಲ್ ಅವ್ನು ಡೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳೋದು ಡೇಟ್ ಗುರುವಾರ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ನೋಡ್ಕೊಡ್ಬೇಕಲ್ಲ. ಶಂಕರ್ ಹೇಳಿದ್ದು
ಇನ್ನೊಂದು ಆಗ್ಬೇಕಿತ್ತು ಅಂತ
ಆಫ್ ಆಗ್ತಾ ಇದೆ ಯಾವ್ದು ನೋಡಿದೆ ನೋಡಿ ಚೆಕ್ ಮಾಡಿದೆ ಯಾಕೆ ಆಫ್ ಆಗ್ತಾ ಇದೆ.
ಡಿಸೆಂಬರ್ಗೆ ಹಾಕ್ಬಿಟ್ರು. ಗಂಟ ಮುಗ್ದೋಗೋದಲ್ಲ ಇವತ್ತು.
ಮೇಡಮ್ 24 ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 2 12 ಕೊಟ್ರಿ. ನಾನು 24ನೇ ಒಂದು ಶಾರ್ಟ್. ಇಲ್ಲ ರೆಡಿ ಇದ್ದಾರೆ ಕೇಳಿದೆ. ಟ್ರಯಲ್ ಕೊಟ್ಟಿದ್ರೆ ನೀವು ಏನ್ ಮಾಡ್ತೀರ ಅಂತ ನೆಕ್ಸ್ಟ್ ಕೆಲಸ ಐತಿ ಇದು. ನಾವು ತಾಳದಾಗ ಕೊಟ್ಟಿದ್ದೀವಿ ಇದು.
Memo book.
ಸರ್ ನಮ್ಮ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ 1 ವೀಕ್ ಆಯ್ತು ಸರ್.
ಸರಿ 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 ಥ್ಯಾಂಕ್ ಯು.
ಏನೋ